This is the Northern
Public. Could I advise the members that the committee meeting will be broadcast throughout Parliament buildings and online? Can I also advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted. They can connect to the Assembly Wi-Fi. Password details are available on the gallery rules. It is not permitted to take photographs or record any of the meeting. Can I inform members that the 3 oral evidence sessions will be Hansarded today? Agenda item number 1 is apologies. Have we any apologies at this stage?
Sheehan, Chair.
Okay. No other members? No. Okay. Agenda item 2 then is the draft minutes of the meeting held on the 10th of November 2016. Can I inform members the draft minutes of the meeting held on the 10th are at pages 6 to 12 of the meeting pack? Can I advise members that there are some words missing from the last action agreed by the committee relating to agenda item number 5, which was the legislative consent motion, the policing and crime bill. Revised proposals at page 9 of the meeting pack. The words "that may need to be" should be added so that the action will read. It was agreed by the committee to write to the Minister of Justice regarding whether she is minded to undertake a review to identify the scale of other anomalies that may need to be addressed in relation to heterosexual offences. Can I seek the agreement of members to change that within the minutes?
Agreed.
Agreed, okay. Can I ask members, are they content with the minute as amended, that they are a true reflection of the proceedings of the meeting? If so, I will sign.
Agreed. Yep.
Okay, thank you. Thank you. Okay, members, moving on. Agenda item number 3 is matters are rising. Item number 1 then, Prisoner Ombudsman investigation report into the circumstances surrounding the death of Mr Ellison. I remind members that the committee briefly considered the Prisoner Ombudsman's report into the circumstances surrounding the death of Mr Jeffrey Ellison in McGilligan prison at the committee meeting last Thursday, following its publication on the 9th of November. The report makes 5 recommendations for the Northern Ireland Prison Service and 4 recommendations for the South Eastern Health and Social Care Trust. Can I advise members that the committee agreed to send a copy of the report to the Health Committee for its information and consideration. The committee also agreed to include the report in this week's meeting papers to give members an opportunity to consider it properly, and that can be found on pages 14 to 33 of our packs. Can I ask members if they wish to take any further action in relation to this report at this moment in time, bearing in mind that we're going to have a presentation very, very soon? Or are we happy to leave it till after that? Okay. Item number 2 then, matters rising. Start 360, a presentation on the services provided to support young people leaving custody. Can I remind members that copies of the independent evaluation of the Start 360 Adjust service, which provides support to young people leaving custody, promotes rehabilitation and reduces offending, was circulated at the meeting last week, and members agreed to give further consideration to a request from Start 360 for an opportunity to present on this programme and its through care models in more detail at the full committee, either at a full committee meeting or in the context of a justice seminar. Now, it might be of order, members, that if the preference of the committee is for a justice seminar, we may wish to propose consideration of holding a number of showcases. There is a number of programmes going on, not just the Adjust service that 360 provide, and it might be better for the committee to hear a number of those at the one seminar. Start 360 do a tremendous job. Others do tremendous work in this field too, so it might be pertinent to get a good whole rounded approach for just a seminar. I'll take your views. If you want an hour briefing as opposed to just a seminar, I'm in your hands, but okay, just a seminar, okay. Item number 3 is Men's Aid. Can I remind members that I held an informal meeting with Men's Aid at SAMI, that you were present also, to discuss a proposal for family law. That was last Thursday, and as agreed, a summary of the proposal for private law early interventions has been provided at pages 35 to 44 of the meeting pack for members' information. I know that they were meeting with a number or several or all of the political parties involved around the Justice Committee's table, so again, if members want to say anything at this stage or have that in mind, there will be opportunity, I'm sure, throughout this mandate to look at law and legislation coming forward that might incorporate something of this nature. I do think we need to do a bit of work on it and see what it actually says to us. So are members content at this stage?
Yes.
Yeah.
Okay. Item number 4, Committee Forward Work Programme. Can I inform members that an updated Forward Work Programme for November and December is at pages 3 to 7 of the table packs? Can I advise members that there are currently 2 oral evidence sessions scheduled for the meeting on the 1st of December, including one with the Minister of Justice, and 3 for the meeting on the 8th of December, including one with officials on the construct of the new domestic violence offence, and an update on implementation of the Executive Action Plan to tackle paramilitary activity, criminality and organised crime. I remind members that the committee has also agreed to schedule oral evidence sessions with Mediation NI on proposals for statutory changes to family mediation, and also with BASC on issues with firearms licensing. Given the volume of oral evidence sessions already scheduled for the 2 meetings in December, the committee may wish to schedule these evidence sessions in January. Can I seek the views of the members on whether they are content to organise in that fashion?
Agreed, yeah.
Okay, members all agreed? So then, can I ask members then to note the forward work programmes, unless they have any comments or require any further information on it? Members are content? Okay then, agenda item number 4 is the legislative consent motion, Policing and Crime Bill, Committee Draft Report. Can I refer members to pages 46 to 71 of the meeting folder for the draft report on the committee's consideration of the legislative consent motion on the Policing and Crime Bill. Can I inform members that any typos or formatting errors in the report will be amended at proofing stage, so no need to worry about that. Can I advise members there are 2 amendments that require to be made to the draft report? The first amendment is at paragraph 17 of the report. This paragraph needs to be amended to fully reflect the committee's agreement in relation to maritime enforcement powers, and to mirror paragraph 49 by inserting the words, quote, subject to the Minister giving a commitment during the debate on the legislative consent motion that work will be progressed as quickly as possible by the Department of Justice to make provision for maritime enforcement powers in hot pursuit situations for PSNI officers, and to identify an appropriate legislative vehicle to give effect to this at the earliest opportunity, unquote. The second amendment is at paragraph 73. This paragraph needs to be amended by inserting the words, and I quote, that may need to be, unquote, to reflect the change agreed earlier in the draft minutes. So again, it's more of a technical thing. Can I seek the agreement of members for those 2 proposed amendments?
Agreed.
Okay. Can I ask members if there are any other proposed amendments to the draft report as they see it in front of them? Okay, at this stage. Okay, I will go through it then. We'll have to go through each the report systematically. Can I refer members to the front page and contents page of the report? Can I put the question? Are members content that the front page and contents page stand part of the report? Is that agreed?
Agreed.
Okay. Background. Can I refer members to the background section of the report at paragraphs 1 to 3 of the report? Are members content that the background section of at paragraphs 1 to 3 stand part of the report? Okay. Refer members to paragraph 4 to 10. The report which outlines the initial proposed legislative consent motions. I put the question, are members content that paragraphs 4 to 10, which outline the initial proposed legislative consent motion, stand part of the report? Content? Agreed. The revised legislative consent motion, refer members to paragraphs 11 to 18, which outlines the revised legislative consent motion. I'd put the question, are members content that paragraphs 11 to 16 stand part of the report? Agreed. Are members content that paragraph 17, as amended, stands part of the report? Agreed. Are members content that paragraph 18 stands part of the report? Agreed. The committee consideration of the policy proposals in the LCM. I refer members to paragraphs 19 to 73, which outline the committee consideration of the policy proposals in the legislative consent motion. I'll put the question, are members content that paragraphs 19 to 72 stand part of the report? Agreed. Are members content that paragraph 73 as amended stands part of the report? Agreed. And in the conclusion, members, can I refer members to the conclusion section at pages 23 and 24 of the report? That's pages 68 to 69 of the meeting folder. And I put the question, are members content that the conclusion section on pages 23 and 24 stand part of the report? Agreed. The appendices then, can I refer members to Appendix 1 and Appendix 2 of the report, which are at pages 70 and 71 of the meeting pack? I put the question, are members content that the appendices stand part of the report? Agreed. Can I seek the agreement of members for the report to be published on the committee's website and issued to all MLAs? Agreed.
Yep.
And can I advise members that the debate on the LCM motion is scheduled to take place on Monday the 28th of November 2016. I no point me trying to promise that I'll try and be calm. Okay, members are content? Okay. Agenda item number 5 then. Prisoner Ombudsman investigation report into serious self-harm incidents by Sean Lynch in Maghaberry Prison. Evidence session with the South Eastern Health and Social Care Trust. Can I remind members that following the evidence session with the Prisoner Ombudsman and Northern Ireland Prison Service officials on the 6th of October 2016 on the report into serious self-harm incidents by Sean Lynch in Maghaberry Prison, the committee agreed to schedule an all-evidence session with the South Eastern Health and Social Care Trust on the healthcare issues highlighted in the report. Can I advise members that Trust officials will attend the meeting to discuss the report? The relevant papers are pages 74 to 146 of the meeting pack. Can I welcome to the Justice Committee Hugh McCarthy, Chief Executive, Brian Mongan, Director of Adult Services and Prison Healthcare, Dr Ian Collins, I hope I've got that right, as with every name, Consultant Forensic Psychiatrist, and Elaine Cole, Operational Nurse Manager, South Eastern Health and Social Care Trust, to the meeting. I advise you all that the session will be recorded by Hansard and the transcript will be published on the committee web page. Again, a very sincere welcome to you all to the Justice Committee. I hope if I have got someone's name wrong, I do apologise now. But I suppose, Hugh, I'll hand over to you to start off with an initial presentation. Thank you.
Okay, thank you, Chairman, and also thank you for the opportunity to attend the committee today and address the healthcare issues arising from the Prisoner Ombudsman's report into the self-harm incidents with Sean Lynch in Maghaberry in June 2014. We've obviously had the opportunity to read the copy of the Hansard report of your meeting of the 6th, so what I'll try and do is address sort of the issues or some of the issues that you raised at that time. Obviously we can explore those and we'll explore those a bit more in terms of the questioning. Excuse me. Firstly, however, let me also reiterate my apology to Mr Lynch and his family. Particularly for the areas where our service did not meet the standard we would expect, or indeed that he could expect of us. The prisoner Ombudsman identified a number of failings and made a number of recommendations. He talked about this being a landmark case, and certainly I hope it'll prove to be just that. It's certainly our intention and indeed our commitment to make sure the recommendations are fully implemented and that lessons are learnt. Excuse me. I believe we can evidence that significant improvements have been made since that time, but I'll return to that a bit later. I suppose maybe if I just touch on the background following the sort of tragic events in June 14, we commissioned our own serious adverse incident review. We chose to bring in independent reviewers so that there would be views from outside the Trust and we would have that independent perspective, and that was valuable. Since the receipt of the report, we've obviously shared that with the Prisoner Ombudsman. Indeed, that was the basis of a lot of his findings. It's also given us, I think, a chance to start to address the recommendations and the issues which arose. And I'll touch on that in a wee bit more in a minute. I suppose, given your discussion the last time, there's a number of points maybe I just want to cover in the introduction. The first of those, I suppose, is around the model of care within prisons, because there's been a lot of discussion about what is available and what isn't. Let me be clear, because we're commissioned and funded to deliver healthcare which is the equivalent to that in the community within the prisons. It's effectively the same level of care as you would get in the health centre, a local health centre, so it's community level standard of care. We are able to enhance that in a number of areas, particularly around things like dental surgery, podiatry, some other allied health professionals like physiotherapy, dietetics, opticians, and also in terms of mental health and addiction. So we do supplement what would be based in the community in the prison setting. But again, each of these services, that will be based on very much around what we could provide in an enhanced way in the community. We're not and have never been funded or expected to deliver inpatient care or care that you would expect in a hospital. The expectation is if someone requires hospital care or inpatient care or secondary care, they go to a secondary care facility, and that includes for mental health. I know that may be, excuse me, slightly confusing, because the report and indeed a number of other commentators have talked about the prison hospital. That was effectively a local name given to a landing in one of the houses where a number of people were housed or accommodated. It effectively operated as an extension of the prison regime. It was not designed and was not built as a healthcare unit and was not staffed as a healthcare unit and designed for therapeutic interventions. One of the reasons we've brought Elaine to my left is Elaine worked in that unit. I know that's an area you'll want to explore. Elaine worked in it. She knows what the unit was like. She knows how it's changed. So I think it's probably helpful when we come to the questions that Elaine maybe gives you a perspective from a clinical point of view of what was actually provided, because I think the use of the term prison hospital probably resonates of porridge a little bit on Ronnie Barker, but it has conjured up sort of images of a hospital unit, which it wasn't. Since the closure of that facility, and the other thing I'd want to stress is that was not done for money purposes, which I think has maybe been implied a little bit. And just to be clear, since we took over the responsibility for healthcare within the prisons, at that time in 2008, 2009, our budget would have been around 6.2 million. It's now around 7.4 million. So we've seen almost 1.2 million more being spent within prison healthcare. So just to reassure, that was not done for financial purposes. But since that time, we've opened, in conjunction with the prison service, the Donard Centre, which is a specific focus on therapeutic interventions and a healthcare, very much providing healthcare, therapeutic care and interventions. We've also extended the treatment room provision to each of the houses, so as we're actually enhancing healthcare right round the prison. Other improvements we've made, we have a new, more reliable committal process, including a mental health committal screening, We've also introduced mental health assessment within 72 hours. Those things wouldn't have been available when we first took over prison healthcare. We've also introduced an addictions team. We've improved health screening. We've a new local pharmacy. So there are a range of things we have supplemented and introduced since we took over prison healthcare. Despite these changes and improvements, we obviously failed to provide the care and support that Sean Lynch should have expected. The prisoner ombudsman talked about the need for learning and improvements. Since June 2014, we have also taken steps to improve services on the back of this case and on the back of other evidence. We've introduced a crisis mental health service. So if you recall at the time, the urgent time for an urgent appointment with a psychiatrist would have been 10 working days. This crisis mental health service means that we can, in a crisis situation, a psychiatrist can be seen within 24 hours. So that's an enhancement to the service since June 2014. We've also introduced a dedicated mental health worker for every mental health patient. If you recall, also the report talks about someone taking responsibility. We've now introduced and restructured our mental health service so that each patient will have a mental health worker, a dedicated worker that will lead the responsibility for their care. As I said, we've restructured the mental health team to make it a much more integrated and, we believe, effective service. We've also introduced a patient safety pharmacist to improve and help us monitor improvements in prescribing and administration of medicines. And we've also introduced a thing called safety huddles, which effectively mean clinical staff getting together on a daily basis in a sort of a semi-formal way where they can discuss concerns about any individuals. And that concept has been developed elsewhere, but we've applied it into the prison healthcare. Having said all that, I still believe we have improvements to make. The Prisoner Ombudsman report reminded us of a number of things, but we were also aware that and recognised there's still a large number of vulnerable people in prisons. That we also recognise that prison is not an environment which is conducive to people's mental health. It's not an environment which promotes good mental health. And we recognise the difficulties in managing patients with escalating mental health problems. In that regard, we have requested and agreed with the Health and Social Care Board, which is the Commissioner, that we establish a review to look at how we can address those particular areas. Those are not things that were specifically covered in our sort of commissioned and funded healthcare at the minute, but they're things that we feel need to be addressed. We would hope that in doing so we'll be able to look at, if we can't have if you like, a hospital within the prison wall, which is not feasible, then what can we do more to provide accommodation or facilities or support for those that are vulnerable or mentally disordered? Also to address the issue of how we can improve access to other escalated facilities, inpatient facilities for psychiatric care, if that's what's required. And also to explore how we can further enhance services for those at risk of self-harm or suicide. We would like that review to involve all of the stakeholders and would expect that it would, including Prisoner Ombudsman's Office, but also prisoner representatives, we would hope. I would stress, please don't see this as any kind of if you like, stalling tactic. We are still proceeding with and fully intending to implement the recommendations. But what we feel needs to be addressed is the areas also where we're not commissioned or funded to deliver certain things. And it's in that regard that we have requested and sought this review. Finally, if I could just close by saying a little bit about the context in which our staff deliver prison health care. I've managed services now for probably over 30 years. I've been a director for almost 20 of those years now. I've no hesitation in saying prisons is the most difficult environment and quite possibly Maghaberry, the most difficult environment in which we have to deliver healthcare. That's down to a variety of reasons. It's an environment which is the prison, but also its regime. Even the types of patients and the environment we're having to deal with and operate in. the prevalence and availability of drugs, and also the difficulty in attracting staff to work in prison healthcare. We have in Northern Ireland somewhere in the region of probably over 1,000 nurses short of what we need. That's been recognised and talked about previously. If you have 1,000 nurses short, and therefore there are posts going across a whole range of areas, you can imagine how difficult it is to recruit into an environment like the prison. We're running at approximately a quarter of our posts which are filled with agency or temporary staff, so that we have been unable to fill. And that's been quite a difficult issue to resolve. It's been, even with a lot of work that we've been doing to try and enhance our recruitment and retention, we're making only slow progress in that regard. And a big part of that is because of the other options, if you like. Having said that, and I would want to finish by saying that we also have some of the most dedicated and committed staff. We have staff in prison healthcare who've won awards for what they do, for the compassion they show, and who actually want to work in prison healthcare and who want to make a difference to prisoners' lives. And in that respect, I think, you know, I would be very positive about those that we have there. So I can assure you in closing that they and we are deeply sorry for what happened to Mr. Lynch, and we are committed to learning the lessons from it.
Okay, thank you very much, Hugh, for being concise and clear in your opening presentation. I suppose I'd preface by saying that I think we realise here in this Justice Committee that what you've said there with regards to working in the most challenging environment for healthcare workers is most definitely correct. So, you know, I think we're all there on that same page with you. I would also say at the outset that there is still this large question mark over where Mr. Lynch should have been placed. That's not a question really for the Health Trust, nor is it even for the Prison Service, I might add. Probably one for the courts and the justice system in a whole to grapple with. And of course, what would worry us in this committee is how many other Mr. Lynches are there in that environment who could well be needing further treatment, more treatment and enhanced treatment than they're currently getting. So we understand the difficulties, we understand the pressures and the stresses and the strains of that environment, and how it would be very, very difficult to administer healthcare in that environment. But no one can probably do it justice better than Tom McGonigal. And on the 6th of October, he was here presenting to this committee as Prison Ombudsman. And I'll read you, as I say, I couldn't do it justice, he has. And I'll read from those, that Hansard, I suppose, of his, I think it was his opening statement. And this is, and I quote, the main issue for the South Eastern Trust is that the forensic medical officer's opinion, which exceptionally was provided in writing to the court and sent on to the prison and the healthcare authorities, said that Mr. Lynch should be urgently seen and reviewed by a psychiatrist. But it was ignored and he was not seen. When he was finally seen a couple of weeks later, the diagnosis was correct. He was in a psychotic state and needed antipsychotic medication. My medical reviewer, whom we retained to look at his case, said that someone with an acute illness such as that should have been seen as an immediate priority once he entered prison, and he should have been commenced on medication straight away. That did not happen, and that is a fundamental failing in a case like this. Then, when he started to deteriorate and his mental health became worse and worse, no single person took care of the patient to help to manage him. Events moved more quickly than the official responses were able to, and nobody was able to keep up with him or to get to grip on matters to ensure that something effective was done to contain the downward spiral. So even in that one paragraph, you can see where there was the forensic medical's opinion, officer's opinion, was passed on to all stakeholders, if you like, prison and healthcare authorities. And Mr. Tom McGonigal uses the word ignored, but it was ignored and he was not seen. He should have been seen by a psychiatrist as soon as possible, and he should have been given or administered medication, which he was not. How do you, whilst I understand what you've said in your opening presentation, how do you address that?
If I start, Chairman, and Bria or Ian may want to chip in also from a clinical point of view, because there's a lot of points in that one paragraph. I'm not sure that you'd say that the forensic medical officer's report was ignored. It was whenever Sean Lynch was committed to Maghaberry. He was assessed by on admission. The assessment, which was classified as routine on the basis of that presentation, on the basis of the clinical opinion of those undertaking the assessment. I think there are probably a number of reasons for that, but essentially that diagnosis, that assessment was wrong. Whilst it was routine and the period of time for routine was longer, he was seen within the period that the timescales we had at that point for urgent. Having said that, we recognise that and have recognised since that time that is inadequate, and that's part of the reason why we have introduced since then this crisis response, where we can now make available an access to a psychiatrist within 24 hours. And in that respect, when Tom McGonigal talked about it being a landmark case, that we have changed things on the back of it, and for the better. So in terms of, I don't think that it was ignored, but the assessment was made. It proved to be incorrect. You can argue there were a number of reasons for that, but the particularly around the presentation being inconsistent, but the assessment was wrong.
The forensic medical officer's opinion, which was provided in writing, how much of that feeds in to the assessment?
I better defer to clinical.
I make a comment, Mr. Chairman. Mr. Lynch was seen on the day following committal by a mental health nurse, part of that multidisciplinary team, and that was a comprehensive mental health review. What happens as a result of that is that's taken to the multidisciplinary team, which includes a psychiatrist, and they will have taken consideration of all of the facts, and they will have made a clinical judgment. Now, with hindsight, our Chief Executive has already said that it would have been better had there been an earlier psychiatric opinion. We accept that. But at that stage, they made a clinical judgment on the basis of all of the information available to them. I suppose for me, in this particular case, there were a lot of healthcare interventions with Mr. Lynch. I mean, if we look at 18 primary care interventions, 2 with a GP, 2 with a psychiatrist, and I think at least in around 8 to 10 with our mental health staff. What that demonstrates is that staff were incredibly busy responding to incidents, and I think the learning out of this is that there hadn't been sufficient coordination and case planning and case management. The other thing I think is really important, and this has been highlighted through Her Majesty's Inspectorate reviews of prisons, the impact of new psychoactive substances. Now, we're talking about 2.5 years ago now since this incident. And it is clear that our staff, Mr. Lynch's presentation was certainly very significant, but it was not consistent. We have, like other prisons, and the community had to begin to better understand just the impact. So I think that did contribute. Chief Executive has also talked about, I suppose, what we've done to really ensure that we have responded to those lessons learned. And I think the main thing is effective case management and coordination, not just across our mental health team, but across our primary care teams. We have one dedicated member of staff, and the potential then to effectively raise an urgent referral for psychiatric opinion. This has been a significant case for the staff. So hopefully that might begin to address some of the clinical decision making, which at that stage what were the standards that they would have been applying.
I hear exactly what you say, Ray, about people being very busy, all staff being doing stuff, and I get that 100%. But I suppose then that's where your standard operating procedures and all the systematic things you put in place are there to actually help and assist with that workload and make sure things are covered quickly. I'll go back to the forensic medical officer's opinion again. It states on it that he should be urgently seen and reviewed by a psychiatrist. He was finally seen a couple of weeks later, and the diagnosis was correct. But if there was more weight that had been placed on that forensic medical officer's opinion, and it was read should be urgently seen, what was urgent at that 2.5 years ago? What would that have looked like? Because it surely should have been quicker than a couple of weeks.
The standard at that stage was 10 days, 10 working days for an urgent. That was the standard at that stage, and it was, in a sense, the standard that would have been there in community. The issue is the potential to escalate concerns in a more immediate way, and that's where the issue around crisis response has been really, really important, and that's the step that we've taken. Those were the standards at that stage, and I think the learning from this case is there needs to be an opportunity for staff to escalate that and to get a crisis response.
So the standard is now then 24 hours?
In a crisis situation, and so you can escalate from the urgent if that's felt clinically by the assessment, by the clinical staff. It wouldn't be everybody within 24 hours.
Could I just clarify what does happen? At the point of committal, there is an immediate keep safe committal. Our mental health staff screen now every single committal, and all of those cases that are referred to mental health will have an immediate first assessment, and that wasn't in place at that stage, and that's for the purposes of trying to judge the risk and urgency rather than, in a sense, the decision around routine. That has been very, very helpful. The standard that we're applying now is for those urgent cases that all of those should be seen within that 48-hour period. And those that require something much more urgent, we have a mechanism in place for that to be escalated. One of the learning in this is our staff, I suppose, were facing extreme challenges. Mr. Lynch's behaviours and presentations was not consistent. At times he was actually very engaged, at other times his behaviour was very concerning. And those changing presentations, in a sense, created for the staff an added complexity. What we have done through the patient safety huddle and through the case management is ensure that our staff have an opportunity on a daily basis to escalate that to senior management, both within prison healthcare but across the trust. And that was one of the lessons that learned, that staff struggling in a sense to best manage something and perhaps not having the opportunity to escalate that, and that mechanism is now in place.
Does that mechanism also then go into medication and the administration of medication? Because obviously it's okay seeing a medical practitioner or specialist or psychiatrist at any given stage quickly, but are we convinced that when we have a robust mechanism in place for crisis response or someone being referred or being seen quickly by a specialist, that whatever that specialist would then say is followed through? Because in this case there was an 8-day delay dispensing the increased prescription and medication.
Mr. Chairman, can I answer that? A delay of that nature is unacceptable. What I would say is the management of medicines in a prison environment is very complex. We have our prescribers, our pharmacy, and then our nurses, and those medicines have to go right through quite a large estate. We, through our own SAI investigation, were able to identify that there were parts of our processes that needed to be reviewed in terms of medicines management, and we brought our Trust's patient safety pharmacist who completed a clinical audit and brought forward very clear recommendations. One of the things I can say is, as a result of that, both the Hyde Bank inspection in 2015 and more particularly the more recent inspection in Maghaberry in both January and again in September, the feedback from RQA has confirmed that we have improved our processes for medicines management. So again, lessons learned in regards to this case, and we have taken steps to improve. Medicines management is incredibly complex in this environment, but we have changed our processes.
Tom McConaughey's words also, and I quote a wee bit here, not go to too much length, but Tom talked about, and I quote, various reviews were conducted. This is in a specific case. Interagency reviews between the prison service and the trust, and internal healthcare reviews by the trust. However, those were pretty meaningless as well. Most seemed simply to set a date for another review. There were no outcomes and no plans for how in future somebody might get a grip on such cases, manage a man's serious mental illness and care for him properly. Where is the line? Is there a line whilst somebody is in custody that healthcare professionals can go in and, for want of a better word, hit a button and say, we're now in charge of this man's health and well-being, and you then take precedent from prison authorities even in that regard? Is there a line there at the present time?
It is very difficult to, in a sense, separate out, obviously, the justice and the health. Our responsibility is to, in a sense, deliver the healthcare. I have already referenced the fact that Mr Lynch's presentation actually changed and fluctuated in regards to hitting a button. Once an individual is committed to prison, even where there's an identification that individual requires to go to hospital, there is a process that needs to take place, and a legal process. And what I might ask is that Dr Bones just talks us through just what that process is. It is really important, because even if there is a bed available, there just is inbuilt into the process with the transfer from a justice, if someone's in remand, to health.
Okay.
Yes, certainly. Thank you, Mr. Chairman. If an individual requires transfer from prison to a psychiatric hospital, there has to be a reasonable degree of a consistent presentation of symptoms. The medical staff seeking the transfer have to locate the trust area from whence the prisoner comes. An assessment team has to be asked to come from that location. The assessment team have to confirm that the individual is suffering from mental disorder of a nature and severity that would require and would benefit treatment. There has to be then a bed sought in the original area from whence the prisoner comes from, and that bed has to be designated based on the level of security, which is determined partly from the individual's mental state and also taking into consideration the type of offence that he has been committed to prison on. If it was a serious violent offence, a bed would need to be sought from the Shannon Regional Secure Unit. If it was a less serious offence, an acquisitive offence, then a bed could be sought in the local psychiatric intensive care unit. So assuming one obtains a bed with an appropriate level of security, then an application has to be made to the Department of Justice. Then the Department of Justice has to give permission that the prisoner can be transferred from the prison to the hospital. Usually that is by way of Article 54 of the Mental Health Order, and there is 28 days allowed for that transfer. in my experience, the best case scenario, if all the props that I've mentioned and all the hoops that I've mentioned have been jumped through, you're still left with the patient in distress in a prison environment for something like 48 to 72 hours, which is difficult and unacceptable when one takes into account the relative speed by which someone could be transferred from their home in the community to a local psychiatric hospital.
And just to clarify, Bones, you're talking about whenever someone is basically going to move permanently.
Going to move for treatment. They cannot move forever. They can only go for a designated period to receive treatment in a psychiatric hospital, and once their treatment is successful and completed, then they must be returned to prison.
Yes. I shouldn't have said permanent, but what I meant was not temporary.
Yes.
That leads me on to my next question in regards that there was on 2 occasions when Mr. Lynch was moved from prison to hospital. One, of course, for the very serious injuries that he inflicted on himself. What it seems to be, reading the report and all the evidence that we've gathered so far, it seems to be the case that there was opportunities missed. What I mean by that was that there was no doubt he was placed in hospital because of his physical injuries. But at no time during that stay, or that through the course of him being admitted to hospital, was his psychiatric health checked or looked at. Is that a feeling? Do you see it as a feeling? How, if someone was to go into prison today for physical problems caused, of course, by mental health, how would you go about treating that patient?
We have anybody in that circumstance, if the staff clinically feel there's a need for a psychiatric assessment, should receive it in the local hospital, in the same way someone coming in from the community would. So they should. We have, since this incident, and Brea may want to comment on the action she's taken, we have liaised with the trusts involved, and indeed all trusts that are local to any one of the prisons, to reinforce that if there is a need for a psychiatric assessment, that should be triggered. I mean, I think as Tom McGonigal alluded, he can only speculate that I suppose staff in a busy ED, when prison officers were there, felt that if he was returned to prison, that the psychiatric assessment would have been undertaken there. That's pure speculation. It still isn't the right thing. The psychiatric assessment should have taken place. We have reinforced and taken measures to make sure that all of the local hospitals are aware of that. Brea, I don't know whether you want to...
Yes, certainly. We've had those contacts and directly with their mental health services as well as their ED, and they are very clear that if a referral is made, they will respond. I think we have further work to do just to ensure that we maintain that contact, and we will be continuing to do that. But we sought immediate assurance in regards to those hospitals that our prisoners go to.
How much of the patient does, in this case, does the staff of the hospital get or know about the patient? Obviously, he's not coming off the street. He's not coming from home. He's coming from prison. How much of a information transfer is there between prison staff, or I suppose the healthcare worker within the prison, to the staff of the hospital on a given occasion? And how does that information transfer from place to place?
I might ask Elaine just to add further comment as a nurse manager, but it would be through either written or telephone contact with those departments generally. But Elaine might be well placed to make comment about just what is routine.
The routine, Chair, is that when a patient is going out to outside a hospital, we usually try to forewarn the ED department that we have somebody coming out to them, so we can give them telephone, what we've actually done, what has preceded the incident, what was the incident, and or the symptoms of the patient. And we also follow that up with either a written letter or a printed letter of the patient's their medical record, their computer medical record, so that would include all the medication that they're on and the last couple of events that have happened.
Okay. There's a lot of members wanting to get in here for questions. Last question for me at this present time is we hear in the report that Mr. Lynch wasn't even helped to get dressed or assisted into an ambulance. Staff didn't even get a wheelchair. Now, I'm not a medical practitioner, nor am I a prison officer, but there just seems to be of a standard of care that you expect if you're in difficulty. How do you address or respond to those comments within the report on that aspect, where it seems to be, even when the injuries had been inflicted, that there was no assistance, or very little assistance given, or no sympathy shown?
Mr. Chairman, first of all, I'm going to say straight off that I would bear that a health professional would have stayed in those particular circumstances, but I think it really is very important that we set the context of that particular evening. And the Prisoner Ombudsman actually does record that a nurse was called, she responded to an emergency, and that she was the first to go into Mr. Lynch's cell. That, I think he used the word, she was brave enough. We need to understand that there was an incident the night before where there was an assault to a prison officer. She certainly would have gone to to respond to the emergency and had a context of whether or not it was safe. What that nurse advises that she left in order to go and complete the written report so that could go with the patient to the hospital. I was concerned, just reading the Hansard, around the comment that she advised other officers that it would be safe to leave him. We can't either confirm or deny that because the nurse currently just isn't available. But I guess I would be concerned that that statement was made in light of the fact that it isn't recorded or commented on. With hindsight, and again, it would have been, in my opinion, better had the nurse stayed with Mr. Lynch rather than complete the written record. But again, I would stress the context at that stage and the perception around the perceived safety. So I would suspect that that probably influenced the judgment that was made. Okay.
Trevor Lunn.
Well, thanks, Chair, and thanks for your presentations. Could you just help me here? What at the time, 14, what would have been the extent of your trust's physical presence in the prison on a permanent basis? How many people and to what level? Who would have been the most senior person, senior medical person available on site?
Sorry, I'm not clear in your question. At what time? At the time of the incident,
or
generally at that time of year?
Oh, general level of staffing present.
Happy enough to respond to that. We have we have 135 funded posts in prison healthcare, and that would be a range of nursing, medical staff, allied health professional staff, and those are reflective of the three
across the three prisons.
The three prisons. That's our funded establishment. We, as our Chief Executive said, actually have been challenged on occasion in terms of recruiting and continue to do so, but I don't know whether you were specifically wishing to talk about the medical staff or just?
I'm just trying to get some perspective on the level of medical availability on site.
At night in
It might
McGappy,
be at night time.
there would be two
Nurses.
nurses. And, do you want to say
Sorry, and that is purely as a reflection of when the prison locks down. They're there for the purpose of emergency response. There wouldn't be, in a sense, a general opportunity for therapeutic intervention at that stage. So overnight, in the late evening, it would be two nurses. They would have access to GP out of hours for consultation, and that would be, the support would be there. There would also be a senior manager on call for prisons. So again, there is an inbuilt mechanism for them to raise those issues.
Is that still same level applied now as compared
Yes,
to then? Yeah.
yes, and generally that level is sufficient to meet emergencies as they arise.
Okay. You've made quite a lot of changes, obviously, in the light of this report, and you've learned from the experience of Sean Lynch's episode. I presume there were previous reports. I mean, self-harm in prison is not an unusual thing. I imagine that based on regular reports over the years, you might have had the opportunity. Some of the changes you've made appear to be quite dramatic, you know, reducing, a 2-week period down to 24 hours and so on. I mean, where was the learning before this happened?
I think we have applied learning from previous reports. As say, we inherited and received the prison healthcare in 2008. And the basis behind that, which was something that happened right across the UK, was that up until that point, prison healthcare had been run by the prison service. And the risk associated with that is that essentially the people running the service have no health background, no social care background, would not, whilst they will get professional advice, there was a risk and I suppose evidence that healthcare in that environment becomes, if it's not run by health professionals, falls behind, gets isolated and falls behind in terms of standards. So I think there was evidence of that. We would have been I think later in that transition from memory than many other areas. I think the other factor for us was that even when the service came across in 2008, actually the staff, the employment of the staff remained with the prison service until around 2012 from memory. So we were, and I have to say it was I talked earlier about one of the most difficult environments when you're actually also trying to manage that service. When you don't manage the staff, it can be particularly difficult. So there has been continual change. We did take previous reports. So some of the things I talked about in my introduction around introducing the Donard Centre, with much more therapeutic intervention, introducing addictions teams. The changes we made to, for instance, committals, the whole committals process came on the back of previous reports, and the fact that prisoners would be admitted without an assessment, and it might have taken some days before they were assessed. So all of that is now built in and is standardised as part of our process. So they're each and every report has been analysed, and we do take the recommendations forward and we do make changes.
Just one more, Chair, if you don't mind. And honestly, if you don't want to answer this question, don't. But well, I'm not. It's awkward. It's
You have me worried.
No, it's not funny at all. Honestly, it's this man, Mr. Lynch, was clearly very disturbed. Fair enough, this situation wasn't handled in an ideal fashion. We all accept that, you've admitted it. If you had managed to treat this man according to your existing protocols at that time, and if everything had been followed by the book, is there not a likelihood that something similar may inevitably have happened? Maybe it's a question for Ian or Elaine, but it's professional judgment. Do you think that this man was an accident waiting to happen? I'm not trying not to be cruel here, or was it? Could he have been treated in such a way as to bring him back to some level of normality where this type of thing wouldn't have happened?
The big feature in the case is the fact that his mental and behavioural disturbance was consequent upon what is called novel psychoactive substances, which are very insidious drugs. They're chemically produced drugs. There's maybe about 60 of these drugs, many of which we don't know the names of, many of which you can't test for. For someone who has taken these drugs, their presentation is very unpredictable, it's very inconsistent. The drugs can give a mixture of presentation, which can be agitation, excitement, behavioural disturbance, or hallucinogenic and delusional ideas, or a whole mixture. This is the great difficulty. The great difficulty as well is that not only is the parent substance psychoactive, the breakdown products and the metabolites of the substance are also psychoactive. This is a very major problem for clinicians. If someone has taken this type of drug, it's very unpredictable, it's very, very difficult to manage. There's no one class of psychiatric drugs that will ameliorate the whole symptom profile, because, as I mentioned, you can go from being deluded and hallucinating to being quite lucid, but very, very agitated, very, very disturbed, very, very distressed. And then you can go back to being hallucinated and deluded again. So within a prison setting, regardless of the procedures, an individual who has taken these type of substances will always prove to be a very major management problem.
Yeah. Well, that's really where I was going with this. That you could have done everything possible for this man, but as long as he had access to drugs that you didn't know about, this was always going to be rather difficult, if not impossible.
Yes,
Yeah.
try.
Thanks, Chair.
Okay, Doug Beattie.
Thank you. And Hugh, thank you for your evidence. You've answered a lot of my questions already. And actually, I'm quite encouraged by your answers. It certainly seems that you've taken this on board, and I think that's a good thing. I suppose I'm looking at this to try and find out a little bit of process, if I possibly can, just so I have a better understanding. Because it says that he was meant to have 6 mental health assessments, but he had 1. So I suppose the question is, whose responsibility is to call him forward for a mental health assessment, having had 1? Who would have called him forward to his 2nd or to his 3rd? I mean, I know that if I'm having a mental health assessment, that I will receive a letter from the health trust say you will attend your next appointment at such and such. Is that the same process? So,
no, it wouldn't be the same process. And I suppose, I mean, I'll get Brea to maybe talk a little bit about the detail, but the process would be different. And I suppose part of the reason we've made the changes to having restructuring the mental health team is to make sure that it is better coordinated, and also the step of having a dedicated mental health worker, so there is one person responsible, which was part of the Tom McGonigal criticism and recommendation, is there was no one single person responsible. So we have taken that on board, and that's part of the restructuring. So we will have a better handle, because you can well imagine within the prison there will be different people on duty at different times, particularly if up to a third at times in mental health of the patients of the staff will be agency or temporary. That further compounds the difficulties with coordinating. So that's why we've made some of the changes we have. Brady, I don't know whether you want to add to that.
Yeah, absolutely. I think the learning from Mr Lynch's case is the requirement for coordination and in a sense one plan. We have introduced what we call a watcher system, which is our mental health team will have an understanding of the individual patients at any given stage that do require enhanced monitoring, and that is in place as a result largely of this case. And that's to ensure that there is a focus on who's doing what. There is one individual case coordinator who will follow the individual through any of the transfers or moves from house to house. So there are a number of things that we've done to really ensure that there is clarity around the frequency. In Mr Lynch's case, the nurse had completed the comprehensive mental health assessment, indicated review, but the issue was there were no dates confirmed. As I said earlier, he had multiple interventions. The issue was the lack of coordination and the steps that were put in place, which is around one case coordinator, and the mechanisms for escalation and support, hopefully, will address the learning from.
Well, and I suppose the point I was trying to get at is there was no call for that second review. You know, it wasn't that somebody ignored a call to have that second review. It wasn't as if something was sent to the prison management board to say, this man should be reviewed now. You know, it's time's up. That's not that. It's
No, Mr
more
Lynch.
nuanced than that.
Mr Lynch actually was reviewed very regularly, and as I said, he had 18 interventions with primary care, 2 with GPs, 8 or 10 with mental health professionals. The issue was that across those professionals there wasn't sufficient coordination, and that's why, as our Chief Executive said, we have completely restructured our mental health team. At that stage, it mirrored what was there in the community. We had, in a sense, smaller teams within our mental health structure, all focusing on different aspects of patient care. We have now actually restructured into one dedicated team, and that certainly has assisted the coordination. The other thing that we've done is actually, and the prison service have been very helpful in this regard, we have relocated the mental health team in Maghaberry so that it's now actually in very close proximity to our primary care. And that's going to be really a focused team in the Donard Centre. So there are a number of ways that our mechanisms that we've put in place to try and assist that coordination. And again, goes back to that issue about which member staff has overall responsibility for care.
Thank you. And if I can, just one. In the report, it says Mr Lynch was treated less favourably in an outside hospital. I mean, I think that's a damning thing to say, and it's not something that sits easy with me. I mean, do you accept that he was treated less favourably in an outside hospital? And if you do accept that, I'm not sure you will. You know, what have you put in place to get staff that they?
I think that was in particular around the access to the psychiatric assessment. Had Mr Lynch come off the street, so you know, I think it is likely that he would have had the psychiatric assessment in the hospital that he was in. I think again, speculating on what I said earlier, is it's likely that in a busy ED department, where they would have been aware that there was a mental health team within the prison, that they speculated that if he returned there, he would get the assessment there. That is misplaced. We have communicated that to the other hospital. I mean, the other side of it, and it's not to balance that or offset that. I think it is quite likely, and I'm sure Elaine might want to comment on this. I think she alluded to it, which is patients who go from prison will quite often be seen quickly and seen as a priority because of the impact they will have on the department. And I think that's so. There are occasions when it's, if you like, there is. It swings the other way because it suits the clinicians and suits the local department to get that someone who has security presence, and particularly if there is disruptive behaviour, gets seen more quickly.
Thank you.
Doug McKerry.
Thanks, Paul, and thank you, Hugh, and to the rest of you for coming in this afternoon. I was conscious, Hugh, in your opening remarks that in a very welcome way you twice registered apologies for what happened to Sean Lynch, both at the outset of your remarks and at the conclusion. You didn't actually deal with this case during your remarks. You told us what has now been done. You gave us some sense of context, but just for the record, I'm noting the fact that you didn't actually deal with the case and the circumstances surrounding what actually happened to Sean and the circumstances which applied to healthcare staff. I'm making that as an observation. I have a couple of questions that I would like to share with you.
Can I respond to that? It wasn't, and I'm not sure how you interpret that, but it wasn't that in any way that I wasn't going to go into the details of the case. We're accepting the prisoner ombudsman's report, and so it was a case more of responding to some of the issues that were discussed on the 6th of October, and which were in the prisoner ombudsman's report. We've accepted it, and that's what I was apologising for. I didn't see the value in sort of rehearsing each of the details of that. So if you feel I should have commented on that, I was conscious I had limited amount of time. So
thank you for that and that clarification. I do think it would have been helpful had you, with your position of seniority, actually dealt with the specifics of the case itself and what has happened, Sean, and I
took it that those were in the report, so therefore all I would have been doing was replaying the report. But
No, I understand that, but from the perspective of your own profession and your own agency, it would have been useful to get a direct perspective based upon the Ombudsman's report, because that is actually why you're here today, to speak to the Ombudsman report and your own area of care with reference to the case of Sean Lynch. But thank you for the clarification. I do think that it would have been useful had yourself augmented your apology by actually speaking to some of the detail in and of itself. Bria mentioned the 18 interventions, which is very, very significant in terms of primary care and so on. Could I ask you whether, in your own senior managerial judgment, 18 interventions eventually has the potential to lead to a form of case hardening, and that perhaps that led to some form of complacency or a hands-off mindset or attitude towards healthcare staff's approach to Sean Lynch?
I don't think that was a factor in this case. I genuinely feel that the staff, as was the case for prison officers as well, were actually struggling with the lack of consistency. This issue around these new psychoactive substances 2 years ago were just emerging, and the learning, and again how we are supporting our staff in terms of training and development over the last period of time. But at that stage, these were very much new and emerging, so it was impacting on staff, and they, I guess, were struggling to respond to the presentations at that time. I don't think that reflects a hardening. I do think, however, it is very important that we support our staff. We're currently doing work with the International Committee of the Red Cross, really around healthcare and detention, to make sure that our staff actually, in terms of ethics and all of those sort of things, have the opportunity to reflect on that. So in answer to your question, I don't think that was a factor. However, it is something that we are mindful of.
Thank you for that, because Doug actually asked a question that I was going to put to you as a corollary to that point. I find that reference to the less favourable treatment reported by Tom McGonigal in relation to Sean going out to the hospital to be quite stark. And I find it difficult to disassociate that observation from the fact that there were 18 interventions and that ultimately we ended up with this tragedy, this crisis, because at the end of the day, Sean Lynch was presenting with very challenging conditions, very challenging mental health. He was a prisoner. He's also a human being. And we all need to be very mindful of the fact that at the end of the day, we're dealing with a human being here, notwithstanding all of the other points that you're making in mitigation in relation to the context of that time.
Declan, could I also just make a comment in relation to that? Because I think one of the things we've done in the last few years since taking over healthcare, and particularly since the staff have transferred across in 2012, is we are a healthcare organisation. Our staff are healthcare professionals. And in a sense, what we've been trying to do is build up our own, if you like, space and culture within the prison that healthcare within prison is just a branch of healthcare. It's not a branch of the prison. Now, we do have to work very closely with our prison service colleagues, and I know that Sue would have talked about the steps they're trying to take to make it a more rehabilitative type environment. But also, we're very conscious that when we're dealing with an individual within Maghaberry, he's a patient to us. That has to have primacy. And that's something that we're reinforcing and trying to build into our culture and our processes. There may be on other occasions when the prison service, they will see the people as offenders or prisoners, or they will always and have to be for us first and foremost patients. And that's part of what we've been trying to build up over the last number of years, that is a part of our culture. It's a part of who we are. It's part of why healthcare was transferred to the Trust, so that it is very much a branch of health and social care as opposed to being a branch of the prison service. And what we're also trying to do is build up the training. Bria talked about build up the ethics, build up the culture, so that it is associated with healthcare professionals, not those that are providing the security.
I suppose one of the additional things we have done is recognise that those staff who work in the prisons need to be integrated within the wider healthcare workforce. So they are involved in professional forums, so the nurse family that we talk about right across the entire Trust. We have the senior primary care nurse from Prison Healthcare who sits on our Trust Nurse Executive. So there's a number of measures to really make sure that our staff constantly get supported to have that primacy. But actually, my name is and a patient first is fundamentally at the core of our service.
And I really welcome that. I think that's an important statement to make here today. I really struggle with that in relation to the incident on the night in question, when no one helped this man to get to an ambulance. Really, really struggle with that.
Can I just say, sir, I struggle with it. I've been a nurse in the prison for 17 years. I didn't know what self-harm was until I came in and worked as a nurse in the prison. The harm that Sean caused himself was unprecedented. He did it by his own hand, but that doesn't make it any easier for us.
No, it doesn't.
It was very upsetting for the nursing staff. It was more upsetting for him and his family. But it's inexcusable, and it's awful for us. It's more awful for him, but what I'm trying to say is we do care. I care about my patients. I would never want that to happen again. I hope we have learned from it. I hope it never happens again. Will it happen again? We can't say whether it won't, because of these drugs and because of the chaotic behaviour that they present with. Yes, could we have done better? Absolutely. Absolutely. And we have good pockets of work that goes on in the prison that isn't highlighted because they don't reach the stage that Sean reached. And that has to be remembered as well.
Thank you for that, Elaine. What happened that night was inhumane. I put that
absolutely.
to...
Absolutely.
I put that to...
if I had been the nurse there, I would have stayed, I would have stayed with him. I would have escorted him to the...
And her senior people that night. However, fundamentally, there were wrong decisions made, wrong calls made, profound errors of judgment on the part of the prison service. And that is the context within which I situate the inhumanity of that night. However, I do find it difficult to reconcile a nurse not intervening or giving other directions to people who should have known better and should have done better from within the prison service on that night. Just to move this on quickly, and then I'll finish. Where are yourselves at in relation to your own commentary reflected in Tom's report in relation to the healthcare observation wing? The necessity for a healthcare observation wing.
That's, I suppose, what I was referring to in terms of the review with the Health and Social Care Board. We don't, and I know there's been a variety of names, including hospital, used for it. We as I say, moved away from that model because it wasn't a therapeutic model, it wasn't but an effective model in terms of healthcare, and we changed the model at that time. We believe, and we can evidence that therefore the service we're offering now is more therapeutic and is improved on that time. And Elaine may want again to comment on that. Having said that, and what I said in my introductory piece is, I think we would want to work with the prison service to recognise there are some patients, prisoners, who there may be benefit in having some kind of facility where we can observe. But that's something, there are alternatives, and I think those need to be explored, and that's what we would like and have sought the board to agree a review, which they have done with us, and we would aim to have other parties, particularly the likes of the prisoner ombudsman, prisoner representatives and others on that group, so that we can actually look at what's best practice elsewhere and what's the best way to provide that enhanced service for people that are vulnerable.
In conclusion, could you confirm for me that the mental health screening process that you referred to, which is now in place, that the crisis mental health service, that is the action within 24 hours, and that the dedicated mental health worker per prisoner, those three points that you've referred to, that they are now currently in place and that they're working? Can you give me a categoric reassurance that that is currently in place?
We have restructured our teams to ensure that our mental health services is much more responsive than it was. In regards to the case management and the issues we've talked about, those are currently in place.
For sure. Yeah. Okay.
The issue, and I just want for the record, the issue around, Hugh mentioned the 24 hours, I mentioned 48 hours, and that just reflects the period perhaps over the weekend and those impacts. So certainly we have enhanced our emergency response. There's no doubt about that, and we have established a crisis response that wasn't there previously.
I'm slightly nervous to give 100% categorical assurance that on every occasion. That's the standard we're operating to. That's what we've introduced. That's what we're monitoring against, and there is always going to be an occasion where we may not meet that, but that's going to be the exception rather than the norm.
But what we can say without exception is that every single prisoner who is committed will have a mental health screen. And I mean, I just want to say that whilst we're talking about a population at any given stage in around over 900, the numbers that went through in committal are closer to the 640 or 600 or 6,500. So there is significant numbers going through, but at this stage we will screen those, and for those that do require a referral, we've established what we call a pre-assessment clinic, which is an urgent face-to-face assessment, so that risk and urgency can be assessed, so that we can better target our resource, rather than people being put onto what would have been a pathway for routine or urgent.
Thank you. Thanks, Paul.
Pam Cameron.
Thank you, Chair, and thank you very much for your attendance here. It's greatly appreciated. I think the majority of the questions I would have had have been asked and answered, and thank you for that and for being frank today with us. I think on reading this report about what happened to Mr. Lynch and what he did to himself, obviously, brings up all the emotions and lots of feelings from all of us, even people who've never met him or don't know the man. I think we were all rightly angered after reading the report, but I do think today's given a wee bit more clarity, and the emphasis are what you told us about the psychoactive substances. That's very worrying. I suppose a couple of small questions, just probably for Dr. Bones, would be around, the problem of the availability of these substances, and I don't know if it would be appropriate to ask this, but I will ask it anyway. Mr. Lynch obviously had mental health issues, but those issues alone, would that have led to this event, or is it the combination of his issues and the psychoactive substances, or could somebody with no mental health issues on taking these substances end up in a similar position?
No. The these substances are so pervasively insidious. I mean, if any of us in this room was to take one of those substances, regardless of how initially well balanced they were, these substances would attack the brain. They would attack the receptors in the brain, the parts of the brain that control your thinking, your perception, your mood state. It attacks those. It is relentless in the way it acts on an individual's brain. So, Mr. Lynch, if he had had previous mental health problems, they would certainly have been exacerbated by the novel psychoactive substances. If he had no significant previous mental health problems, these substances would create those problems de novo. I really can't underestimate and underplay how horrific these substances are, as are any drugs, really. I'm not saying that substances that we already know about, such as cannabis, etc., are acceptable and benign, but these novel psychoactive substances are particularly insidious.
I think that out of today's presentation gives me the most concern, because how do you fight that?
Yes.
As a body of healthcare, how do you fight that? It's really unfightable, it's uncontrollable. So I suppose that's another issue to go back to the prison service with themselves. Something else I wanted to ask you as well. Yes, you talked, Dr. Bones, again about the process and the length of time to process in order to get psychiatric, I suppose, outside help.
Yes.
And 48 to 72 hours, which when they're in a great deal of distress is a horrendously long time, and a very long time for staff to have to deal with individuals. Is there red tape that can be cut, in your opinion, to shorten that process, or is there an opportunity to review that process?
I think
view to shortening the length of time.
I think the whole process should be reviewed, because I tried to outline the various steps that someone such as myself seeking a bed would have to fulfill before we could transfer our patient. And it takes time, it really does, but I do think it could be reduced down to 24 hours plus 24, 48 hours. And I've already said it's something like 48 to 72 hours minimum. I think we could reduce that by half. But that would take a combined response of the Department of Justice and the health trusts, who would make a facility available to take someone. But there are various things that could be done, I think, to circumvent those, but it's certainly worth looking and review.
Okay, thank you very much.
Okay, Sammy Douglas.
Thank you, Chair. Thanks very much for your presentation so far. It's been very helpful. Ian, could I get back to I think you'd said that there were 60 different types of substances.
Yes.
Could you name any of those ones that would be familiar to yourselves? I'm not quite sure what sort of substances you're actually talking about.
Well, there's various substances, crystal meth, China white, various. Those are names that we might be familiar with. But then there are substances that are purely chemical formula. If I wanted to make a novel psychoactive substance, I would know what the structure is, and I would create that. Then I would experiment by adding on perhaps oxygen or other molecules to that parent molecule, and I would pass that out and see what effect that would have on the drug-taking population. It might have no effect, or it might make people more excitable. It might help them hallucinate in a more interesting way. So I would then think that that's quite good. Let's make more of that substance. Now, if I make more of that substance and distribute it, then eventually the police and the laboratories are going to catch up with me, and they're going to be able to identify that and name it. So what do? I add another molecule onto the substance. That means that the test the laboratories developed to get my substance identified, that no longer works. So I get a sort of free run for another few months until someone catches up with the whole process. So it's laboratories and people who do good, who are worried about the effect of this, have to really run hard to catch up. And it's a constantly changing scene. I mean, I'm a clinician, I'm not a pharmacist, but that's what I've been told about. So even though I mentioned 60 substances, there's probably 70 by the end of the month. There could well be more. It's such a constantly changing scene.
I suppose every prison would have problems with the drugs right across, go say Western Europe, but across the world.
Absolutely.
Is there a potential for a similar traumatic situation to develop within some of our prisons with these substances you're talking about? And what's the potential for something like this to happen again in McGabry? If these substances are available?
If these substances are available, then you cannot discount an episode such as this happening again. But as we've already mentioned, we have learned, unfortunately, with the help of Mr. Lynch, we've learned a lot about the way these substances act, and unfortunately, what is known about what is currently known about the substances is based on the investigation of adverse reactions, not only in Northern Ireland but around the world, and those are reported in the medical journals. So we will learn from this, and we will be able to, at a much earlier stage, raise the question, has this person in McGabry taken a novel psychoactive substance, as opposed to saying he may well just have taken an ordinary substance that we already know about. So that's high in our index of suspicion now.
But in addition to that, I suppose what we have in place is a process for staff to escalate when behaviours, irrespective of how they are caused, and seek that support. And I think it's down to, and again, these cases are cases that need to be case managed across both healthcare and the prison. And I know that our mental health lead has done work in McGabry around recent cases, just to ensure that there is a case management approach, an integrated case management approach with the prison service. And I think we need to do more in that regard in response to any future, so those early alerts and the warning signs are responded to.
Just a couple of quick questions. In terms of Mr. Lynch, do you have any responsibility for him now? And if not, at what stage did your responsibility finish?
Mr. Lynch lives in the Western Trust area.
Yeah.
We provide care within the context of the prison. It is really, really important. The vast majority of people who come into prison actually live most of their life in community. You know, there may be individuals who stay a little bit longer, but the vast majority come from community, go back to. And it is the trust where he lives would have the responsibility for him.
And just finally, obviously this was a traumatic experience, not just for Mr. Lynch, but his family. Do they have any sort of help and help and support from yourselves, or say for any family that goes through this sort of traumatic incident?
One of the things that we did as a result of our own SAI investigation, our senior team, and that's our mental health lead and our primary care lead, actually met with Mr. Lynch, his father, in their own home. And one of the things they wanted to do was to, in a sense, ensure that they were aware of how to seek support. So they did have that discussion with the family in regards to whether or not there was something we needed to do with the Western Trust area. And I think, I mean, certainly this is a lifelong impact, not just on Mr Lynch himself and the family. So that was something that our staff really were seeking to check out with families.
Certainly, it's very encouraging that you actually followed up on the family as well, then, Bray, so I appreciate that. Okay, thanks very much.
Okay, Claire Bailey.
Thank you, Chair, and thank you very much for your presentation and coming and speaking with us today. I suppose I'm very interested in the patient versus prisoner debate as well, and when you're dealing with someone, you're dealing with them as a patient, you're dealing with them in an environment where they're a prisoner of the justice system, and I do get that poses very specific circumstances, and you already mentioned, you know, that dealing with people in the prison system or dealing with people with mental health problems specifically within the justice system is a very tough place to be, but you also identified that Maghaberry specific and how hard the regime is there, and I think everybody here is very aware of the report that has come out, you know, very critical of the Maghaberry system as well. So maybe I want to ask you, in your assessment and with the people that you're dealing with in the prisons, what percentage would you believe in Maghaberry itself who would suffer from serious mental health problems when you do get access to them when they are committed?
I'll maybe get Ian to comment on that, because I think there has been a, you know, it's where I sort of winced a little bit when you said serious, because there's been a use of a variety of terms to describe the level of mental ill health or mental illness within the prison. And I think a lot of us are using it as lay people, and so the number that will have a severe mental illness in the clinical sense will actually be quite small. But there is, and I think we talked about in around 30% of people will be referred to mental health, so will have some form of mental ill health. And that could cover a range of things which Ian or Elaine may want to comment on. But that's going to be, the majority of those are going to be much more akin to what would be in the community. The number that will have a severe or serious, using layperson's terms, will be quite small. Ian, do you want to?
Yes, certainly. In broad terms, individuals who have mental health problems in the prison, and we're talking principally about Maghaberry, the rule of thumb is that about 25% of the individuals referred to the mental health team will have serious mental illness problems, i.e. schizophrenia, drug-induced psychoses, bipolar affective disorder, severe depression. And 75% of the referrals to the mental health team will have significantly distressing conditions, but not conditions that meet the criteria for mental illness for transfer under the Part 3 of the Mental Health Order. But that's not to belittle the level of distress that those conditions, those difficulties can cause the individual. In 2014, I did an audit, and I listed here the psychopathology in 200 non-psychotic referrals to the psychiatric services at Maghaberry Prison, and 48% of those referrals were suffering from significant levels of anxiety. 65% were suffering from low mood, unhappiness. 38% were suffering from thoughts of self-harm. 52% were suffering from low self-esteem problems. And 42% had post-traumatic stress disorder type symptoms. 23% had difficulty structuring and ordering their thoughts, and 25% were persistently having difficulty focusing and concentrating. Now that's quite a high level of morbidity, but none of those individuals would meet the criteria for transfer to a psychiatric hospital out with the prison. But that is the level of morbidity, level of psychopathology within the prison population. And I stress those are disturbing and distressing symptoms for the individual. But they do not meet the criteria for mental illness and for transfer. So from that point of view, they would not be considered severe and enduring mental illness, but quite a lot of problem areas in the prison.
And then I also picked up then here, I think you said that up to a third of your staff at any given time are temps.
It would be, in overall terms, it's about a quarter, but the vacancy level has hit a third in mental health in Maghaberry at a point in time.
Okay, and
It is also difficult. What we're finding, as I mentioned, is that it's difficult to actually, given the vacancy level across for nursing posts across Northern Ireland, to actually recruit. We've done an awful lot of work to try and retain and recruit nurses, and we're making progress, but it's always slow in this context.
I think it's very important to have a comment about the agency, because that might suggest that that is a fluctuating group of staff. Actually, our agency tend to be some of our more experienced staff, and we can't go to any agency and just say there's a shift in the prison. Obviously, we can only recruit staff who have been security checked, etc. So, you know, we do have a cohort, and there is a particular nursing agency who supplies. So there is, in a sense, a level of expertise. So whilst we are absolutely committed to permanency, and we are constantly out to recruit, I just want to assure that that is not a situation where it is a constantly changing staff profile. They tend to be staff who work consistently with us.
thank you. I was picking up it because it was mentioned earlier as well that there's about 1,000 nursing places shortage across Northern Ireland as well. So if it is, you know, an area of high demand, I imagine that staff can move freely within the workforce. So recruiting or holding on to your staff must be a hard challenge at the minute. But what I wanted to ask is, was there any specific measures being taken to try and have you equipped with a permanent staffing team at staffing levels or proper levels?
Yeah, we have left no stone unturned. I mean, we have our whole corporate HR department working with us in this, and we are doing a number of things. We have revised the induction for staff going into the prison. We now have that supernumerary. They have a 6-week induction, and that's not just to ensure that they are equipped to deal with healthcare in the prison, but also actually they get a better understanding of the prison regime. So there's a whole host there. We have offered bank so that people can come in and sample. So some of our recent recruits actually have been through people who have had the experience. We have developed value-based recruitment, and Elaine has been very involved in that, which is to make sure that there's not a disconnect between expectation and the job. So there's a whole host of things that we're doing. And the other thing is, I suppose, just supporting and developing staff, the training. We have training events that happen very, very regularly for our staff. So there's a whole host of things. The other thing I just want to say in agencies, I think it's fairly important. In our primary care workforce, agency, in a sense, can be very effective. However, when it comes to mental health, the nature of mental health interventions, that isn't something that we use. We will work to prioritise the resource we have, simply to do with the importance of that continuity of care in a therapeutic relationship. I just want to be clear.
Tough job. Then maybe...
But actually, I would just make the point, that, again, reinforce, we are fortunate. There is a core of our staff, medical and nursing and allied health professionals and dental, who actually are very committed to this service. They like working in it. I mean, you've heard Lynn, she's worked 17 years, and it probably takes there are people who it appeals to, and we're trying to maximise the number of people and people who see the benefits and see how much it is valued, because this is a group of people who generally, as we've talked about, can have a lot of vulnerabilities and comorbidities. So it's very important, and we're very fortunate to have the committed staff that we have. We just need a few more of them.
but I think we do, and we have had meetings with the police service recently in regards to their FMO services. We need to raise the profile of forensic practice right across, and I think there's further work that we need to do to incentivise this as a positive area to work. But Hugh is absolutely right. We have staff who are very, very committed. And
Maybe just going back to the drugs in prisons issue again as well, and if, you know, I think your figures were startling there too, but how prevalent do you feel that the use of illegal drugs or drugs being smuggled into prisons is in terms of an issue dealing with your patients?
I don't think we can comment on that, the sort of volume or the how. As Dr. Bones said, it is a real issue, and it's a Sue McAllister and I know others have presented to you before in that regard. It makes life very difficult. That's part of the reason why it's such a difficult healthcare environment, because in a sense you don't know what some of the substances are that can, as we've heard in this case, can create inconsistent presentations, makes diagnosis much more difficult. But the other side of it is as you try to change it, and we've had the situation in the last month where we've had several staff assaulted where they effectively, because they're trying to manage the drugs that people are on. And only this week we've had another person assaulted, but we've had several assaulted this month.
And is there anything going on just within the wider prison, hopefully with yourselves as well, to try and put some sort of alternatives in to give prisoners or patients, depending who you're dealing with? Obviously it's double identity that they carry with you there.
I think that actually is a really important point. I just want to be very clear that the issue of drug misuse, we are very committed to working with our partners in the prison service. We need to ensure that our medicines management is as effective as we can have it. We need to challenge ourselves in terms of creating some of those alternatives. And one of the things that we are currently looking is the issue about managing pain. I mean, chronic pain is an issue in terms of prescribing, and the prison service and ourselves are working to see whether we can, in a particular landing in Maghaberry, do just that, actually work with prisoners on a proactive way to incentivise and provide alternatives. But I mean, that goes down to, in a sense, having a meaningful and productive day. It also means that we have to offer alternatives through our physio to manage that pain. So there's a number of things that we have considered, but we'll be doing those in partnership. Mental health and the types of services that we provide, it is very tempting to say it's all about seeing a psychiatrist and all about seeing a mental health nurse. It absolutely isn't, and the range of conditions need an absolute range of responses. And one of the things that has been absolutely superb, we have a therapeutic choir now operating in the Meadbank Care College for both the women and the young men. And that has been evaluated, and there is a perfect example of a completely innovative and different approach to deal with, in a sense, ongoing mental health issues. Those were young men who would not actually have chosen to engage in mental health services, see a psychiatrist, sit down, thank you, no. But actually through the engagement of music, the outcomes for some of those young men. So, you know, that is a result of just perhaps a degree of innovation and trying to think through. So in answer to your question, we need to be doing more of that.
In relation to the choir, just in case it sounds like it's a nice thing to do, it actually has reduced behavioural instances of violence, so that it's the impact is measurable in terms of outcomes. It's not just a nice diversion, if you like.
No, I mean, we were able to take a baseline in terms of the improvement in mood and the improvement in coping. So, I mean, that's all been evaluated, but we need to do more of those.
Arlene, you want to do?
Yeah, I can't stress enough about the environment. I mean, I think you all agree that Maghaberry is not an environment conducive for anybody. I've worked in all three prisons. And I currently work in Milligan. I have seen patients who I have dealt with in Maghaberry who have been disruptive, who have taken drugs, who have fought against the system, who then are transferred down to McGilligan and within a matter of weeks are different people. And that's all to do with the environment. I strongly believe that. McGilligan is, they call it the open prison, but it's not an open prison, it's still within the prison. But there's a relationship that is developed between all the staff and the patients. It's first name basis, it's very relaxed. Patients are encouraged, or prisoners are encouraged to go out to work, to go to the gym, to take part in constructive activity. And it's that freedom and that empowering those people, those individuals, to take responsibility for their own health, take responsibility for their crime, for what they've done, and to rehabilitate them. And that is, if they're locked in a cell all day, they're going to look for drugs, because that's the only way that they can get their head around it. But if they get out of cell activity, that is the key. And until Maghaberry is in a position to do that, it's never going to be fixed. No matter how many nursing staff we put in, no matter how many psychiatrists or any of that, unless we change the environment, we're not going to change it.
Thank you.
Okay, Roy Beggs.
Again, thanks for your evidence to date. It's such a tragic case, how Sean Lynch inflicted severe wounds upon himself, life-changing. It is important that we learn any lesson that can be gained and increase protection for others that lessen the likelihood of anything like this or aspects of it repeating. And I'm pleased that you have created a single medical team, or it seems to be common sense, so that there's better information flow. But I'm still going back to this issue of a third agency staff. What is the South Eastern Trust doing to ensure that there are going to be an adequate number of trained psychiatric nurses in particular, and other consultants, etc., in this very difficult environment? And it's probably not even just the South Eastern Trust, it's probably at a Northern Ireland pool level. So what is our health service doing to make sure that we have an adequate number of trained specialists to deal with mental health issues in our prisons?
I mean, there's a lot happening in a broader sense at a regional level. There has been a number of regional overseas recruitment exercises. As I understand it, there's also additional nurses being trained. There's an awful lot of work being done to return people who formerly were nurses back into nursing, and also to retain people within the profession. So that there's quite a number of things that are happening at a regional basis. In terms of locally, we're obviously participating in those things. We've also done a lot of work in terms of trying to understand why people come in, what skills they need. We've done a lot of work in terms of trying to improve the training, the induction for staff coming in, so that we don't. It is a different environment, and there's a different set of skills and mindset, and there are people who it doesn't suit, and it's better to know that as early as possible rather than have people come in and have undergone all the training and then find they don't like it. So there is lots we're doing. We also, I think one of the things I feel is important is we raise the profile, because there's an awful lot of good work done, and unfortunately, you know, committees like this will only hear, and the media will only probably portray and hear about the ones which are negative stories and where the failings have been. There are lots of good examples where, and I have seen letters where prisoners have written back to say basically to the staff, thank you, you saved my life, you made a difference, you know, and turned them round. And we've had quite a number of instances of those. We as a trust try to make sure that we highlight those, we value those, we show to the staff that we value them. We've brought them to Trust Board, we've had a number of stories. So I think we do as much as we possibly can. We're also looking at a range of things around the recruitment, see if we can do more. But it is, at times it feels like sort of 3 steps forward, 3 steps back. And there can be things that happen that just sort of blow progress out of the water. And I suppose when we go back to 2014, there was a threat made to staff generally at that time, and that there's a risk level associated with the post, with working in the prisons. That can all affect, if you're a nurse that can work in Lagan Valley or the Royal or somewhere else, and suddenly there's an issue about a threat, then that can change people's mindset, and did, we know. So there's a range of things, and it is a particularly difficult environment.
You mentioned overseas recruitment. That's maybe a short-term measure you have to take. Appreciate that. But in your professional opinion, are we presently training enough clinicians and nurses in this specialist area? We
wouldn't train nurses specifically for prison healthcare. They will do sort of the normal nursing qualifications, and then we will have nurses that come in as primary healthcare nurses, and we'll have nurses that come in at mental health, and they will have different sort of subspecialties. I think there's a recognition that at the minute we do not have enough nurses in Northern Ireland trained, given the number of posts we have. There is a plan, I can't remember all the detail of that, but around in increasing the numbers of nurses that are being trained. But obviously that, putting more nurses through your own training regime, it's the same as with the increase in general practice that was announced. It does take a little bit of time to work its way through.
Looking through the Ombudsman's report, and again the evidence that you've presented here today, the issue of drug-induced psychosis has been mentioned, continuing drug use has been mentioned, and chaotic behaviour, that was referenced. And in the report it talks about drugs or gambling debts, which would have an adverse effect, I no doubt, on an individual's mental health, another contributing issue which would be unhelpful. And then there's mention of drug screening. I'm actually very conscious of a programme I saw, I think this last week on Channel 4, The Secret Life of Prisons. Is that what's going on in our prisons?
I didn't see the programme, and
I didn't see it either. I heard of it,
so
but
I don't think
essentially it was free association of prisoners taking psychoactive substances, significant bullying going on, people who wanted them actually allowing other prisoners to inflict violence upon them to get the drugs. Chaos, I have to say. I mean, is to what level are these?
we don't have the same level as the mainland. We don't even have the same level of IV drug use as the southern prison, the south of Ireland. Intravenous, sorry,
right.
intravenous
IV,
drug use. We don't have that level that there is in the mainland or in the south of Ireland.
Yeah. Having said that, I think that question is probably one which is better addressed to the prison service. But
I'm sure as clinicians you will have come up against it. If you're trying to treat someone and someone his behaviour is erratic, not because of their normal mental health, but because of substances that they're taking, what sort of challenge is that to yourselves? Can you treat someone in that situation?
Dr. Bones has already commented on that in terms of the impact that has and the difficulty it can make in terms of those behaviours, the inconsistent presentation, therefore on the impact on diagnosis, but also in terms of the general provision of services. That's clearly difficult.
I certainly think that the most important thing that we've learnt is the requirement for health and the prison staff to work together when these particularly extreme challenges arise. It's that combination of the expertise from both that we need to do further work on. And
can I ask the question about the adequacy or otherwise in terms of screening which would be going on when there are prisoners who have addiction issues and presenting mental health issues as well? Are you satisfied about the adequacy of drug screening that is going on in our prisons?
Again, I think that's a matter for the prison service, who clearly do drug screening. For clinicians, if they require to test someone, that provision is there. If that's done for a therapeutic, that is slightly different from the information or the record, which is that wider prison system and testing for drugs.
So are you saying that the clinician, if they have concerns that erratic behaviour may be drug-induced, they can require a test to be carried out?
We can do, but I think, as
They can
Ian
decide.
mentioned earlier,
Yes, because
that actually, if the nature of the drugs keeps changing, it's actually quite difficult, and it may not be of value in identifying some of these substances.
And can I ask, in terms of
That was within the report, right?
in terms of the testing regime in our prisons, which is helping you to try and find out how prisoners are behaving in terms of their mental health, how up to date is our testing compared to the testing in other prisons?
Again, I think that would be something, if the prison service are conducting it, I wouldn't have information as to how it benchmarks with what happens anywhere else on these islands, so I couldn't comment.
Okay, thank you.
Okay, Alex Abbott.
Thank you, and could I apologise that I missed the most of your presentation at the beginning to take a call. So could I ask you, like there's 26 recommendations from the prisoner ombudsman falls to yourselves, and the rest fall to the prison service, but in one way they all fall to all of you.
Yeah.
So can I ask you this question? Given the comment that was made earlier about the need for integrated care management approach, do you have concerns about the prison side, the prison management side and the prison officer side of having that integrated care management? In other words, in respect of the other recommendations that fall to them and the ones that are particular in terms of medical assessment and care, do you have concerns that there is, as we sit at the moment, something lacking in terms of the integrated care approach?
Do I have concerns? No, I don't think I have concerns. I think we have been doing a lot over the last number of years to improve our working relationship at all levels with the prison service. And we at a senior level, we have been working closely to make sure that we actually align what we're doing more closely, and that we do work more effectively together. We're working on a number of policies, we're working on a number of arrangements where things like, for instance, the mention of the choir, it was an initiative developed by our staff, but it couldn't be done without doing it in conjunction with the prison service. They've embraced that. A lot of the things we're doing together. I think we're also seeing improvements at the operational level. We're getting better at in a whole variety of ways in terms of our staff inputting into SPARs, in terms of sharing of information. But it is, you're right, there's still more for us to do, and I think in a way we're breaking down some of the culture and the history and the practice of the past to make sure that we have a better integrated approach.
That if the integrated care management approach was stress test now, this week, and I'm not making any comment on any particular case because those matters will be investigated. If the integrated care management approach that you talk so highly about, that has developed over the last number of years, was stress test today in terms of the interface between the prison management officers and your own staff, are you satisfied the stress test will be passed?
I am clear that our mental health team are working with the prison staff in Maghaberry around this issue. I am confident that at any given stage, now this is again those where there are warning symptoms and increased concerns, that they will be working collaboratively with the prison service. This is, I suppose, a complex issue in terms of the difficulty around predictability in some of these scenarios. All I can say is, over the recent past, certainly the prison service, governors and myself have recognised on a case-by-case basis, and I can talk about 3 that came to my attention, where it actually did demonstrate the benefits of that one plan integrated approach. We have further work to do to embed that. So these small cycles of change where you try something and it works actually is what we need to then do to develop that at scale. So in answer to your question, am I confident that a stress test would? I am confident that we have made a good beginning in regards to trying to work in a much more collaborative way with our prison staff. I think this isn't down to the prison staff, it's not down to South Eastern Trust, it's down to, in a sense, the challenge of supporting vulnerable people together.
I agree with that,
I think
because
with further
it's
work
always a person who's not in custody before they go into custody, and the issues that they have are long in their history and development. The reason why I ask you is that, so if we were to ask you today, is recommendations 43, 44 and 45 about collateral history from the prison service, collateral history from families and mental health care plans, if they were stress tested today, you would be, and there's no absolutes here, but you are saying with a high level of confidence that those systems and the outcomes arising from those systems would be in place?
We have integrated our team to make one integrated team. As part of our operating procedures, there will be a care plan for each of the individuals who are known to the mental health staff. So that is absolutely in place currently. The issue is, I guess, the wider integration across the prison staff and the South Eastern Trust. And that's why I referred to those more recent cases where we've been able to demonstrate that we've developed that. The other thing I suppose we have done is that we have various teams within the prison, our primary care staff and our mental health staff. So we have a safety huddle every single day. The mental health and primary care staff can collaborate, they're there together with the sole purpose of actually talking about their respective concerns with you two, having an integrated plan across primary care and mental health. There's a difference between actually starting a process and actually embedding it. So yes, we have started the process. The work from here is to embed it so it's the first time.
Is the embedding of these new procedures and the recommendations, how is that getting externally verified?
We would be subject to inspection by our Regulated Quality and Improvement Authority, and
have they been in?
They have been in. They were in January. They were in again in September. That report is to be published, but certainly we've had feedback, and what they've been able to share with us is that since January through to their review in September, the mental health services had improved.
We'll wait to see the words of that report. I would expect there to be improvement. The real issue is the scale and speed of improvement. Let me move on. One of the recommendations that surprised me, or one of the comments in the original Ombudsman report, was the fact that there had been this delay in prescribing medication to Mr. Lynch. Surely, I presume there must be some red light system in place in terms of the prescribing drugs, where something that is deemed to be urgently required and acute is provided, rather than, because your answer, Doctor, earlier was that the prison estate is a big place, and moving drugs and managing prescriptions is going to have certain challenges. But putting that aside, is there not some red light warning system in respect of certain prisoners and certain drugs, that they need them now, not 8 days later?
You're absolutely right. The issue of medicines management is a priority. We have been continuing to work on that. It's not just down to the logistics of it. There is a manuscript. What we have done is through the audit with our patient safety pharmacists is identify the areas that we could improve our systems, and we've done that. What I would rely on is, again, the Regulated Quality Improvement Authority, who will come in and assess whether or not those processes are satisfactory. So again, we will await the report.
I appreciate that, but in this case,
yeah, it's unacceptable.
But was there not some red light system that said this person, given the psychosis and the overall vulnerability, and that something in the system didn't say, you have to move immediately in 8 hours, never mind 8 days?
One of the things we say to you, in this particular case, this young man was moved frequently across the prison estate. One of the things that we've done in regards to the mental health with that case coordinator, they now have responsibility for monitoring, say for instance, if it would be an antipsychotic medication. So again, it was a measure that we've put in place to try to ensure that if someone is in receipt of mental health services, that case coordinator has a responsibility to make sure that happens.
But at the time, those systems weren't in place.
I think it was a combination of he was moving quite frequently, he was being managed by different staff. The issue is in regards to mental health and the maintenance of antipsychotic medication, that would be an important thing, and that's what we now have a dedicated member of staff who will follow.
Sorry, I'll just ask one more question this matter. I don't understand how the size of the estate and a patient or a prisoner being moved can explain that somebody in a dispensing pharmacy and the doctors responsible didn't say, this is of such urgency, we need to find where he is in the prison estate and give him his drugs. Is that not a fair comment?
There isn't a system, an electronic system, which is flagging up that whether or not people have got their drugs. So when you talk about a doctor at the centre or a pharmacy saying, well, has so-and-so got their drugs today, there wouldn't be that ability to monitor that on an electronic system, for instance.
Although in this case, I'll leave the answers rest there. I think it says what needs to be said. Could I ask you, one of your colleagues in Liverpool, who you know, is actually in Belfast today, the head of the Liverpool Trust from Portadown, Joe
Rafferty.
Joe Rafferty, yes. All of the staff within that trust all get suicide awareness training and self-harm training. I think they now got to the point of 3,400 staff have got it. And that's also part of the recommendations in this report about suicide and self-harm prevention policy and definition of self-harm. Are all the staff in the prison, be it prison side or your side, are they all now trained in?
We're committed to ensure that each and every one of our staff have access to, we use STORM training, which is a skills-based training, and that's a rolling process, so all staff will progress through that. As part of the induction also I talked about, all of our staff then get an introduction to the supporting our prisoner at risk, the Northern Ireland Prison Service process as well. So we are really focused on the importance of raising awareness and making sure that all of the staff, including in a sense some of those staff who may not be as front-facing, our pharmacy assistants, all of those now we are progressing through. I think that's...
Well, we'll come back to this, I'm sure, given tragic recent events over the last number of days and months, about to see how that level of training and policy is working in real time in the life of prisoners and the prison, because whatever institution it might be, or voluntary organisation or social organisation, this issue of suicide and self-harm prevention and awareness is so critical, and it's also increasingly critical, it appears, in the prison estate. Just two very quick questions. First is, Joe Rafferty also says that, and I want to make it very clear, I'm not talking about any case now, but I just want to get the view of you as Chief Executive of policy here. Joe Rafferty is now introducing a policy of candour when it comes to critical instance and death, where culpability to a greater or lesser extent falls to health authorities. Do you have a duty of candour or an approach of candour when these sort of cases arise and actions are then taken in relation to the fate or otherwise of the prison or of the health board or whatever, health trust or whatever it might be?
At a personal level, I think that's the only way we can deal with this. I have a particular interest in the whole, there's an international patient safety movement, and central to that is that no healthcare system gets it completely right all of the time. Healthcare systems tend to be very complex, and there's issues right from harm happening, where perhaps people pick up an infection, where perhaps something is done which harms the patient, to things around the resilience of the system, where it doesn't happen every time, it isn't fully embedded, it only happens a certain percentage of the time. So every health system is in that position. I think the critical thing for us is building an approach and a culture and a commitment to us continually getting better. And when we don't, is that we're quite open from that, because there is greater learning in many ways from the occasions we get it wrong, providing we're open, transparent and completely candid about that. To be clear, I have, it is always probably the most personally difficult thing you have to do, but whenever we get it wrong, I do meet families and individuals, because, and very early on, we would try to say, if we've got it wrong, say we've got it wrong, and we will give you all the answers we can, because that's, in a way, it's back to some of those sort of famous quotes around if we're getting it wrong one time, but if we actually then aren't open and aren't are completely transparent and answer people's questions and queries, all we're doing is compounding the pain. So at a personal level and as a public servant, I think that's the only way we can practice.
I look forward to that being applied in terms of information to families and responses to families, interventions, whatever their character may be, as a touchstone, as a template against which you should be judged. The final question is this is very simple, but and you may well have touched upon this at the beginning, although Declan's question indicated that he wasn't completely convinced that you had touched upon this. I'm not quite sure if you view this as a case where there was insufficient coordination in terms of what happened, or actually it was a complete systemic failure by the relevant authorities. And I think it was the latter, rather than a failure of cooperation between people and agencies.
I suppose my view, sorry Hugh, is, and again I looked at what Tom McGonigal wrote in his Ombudsman's report, and indeed his evidence to this committee, which was that it wasn't a systemic failure but a series of, in a sense, individual judgments that accumulated. I think all we can do is actually look at the learning and bit by bit actually improve processes in the communication, and that's what we're attempting to do.
And I think there were a number of things, as Brea said, aligned. There was, you mentioned insufficient coordination. That was one aspect. I think that, as was recorded in the Prisoner Ombudsman's report, we failed to make the diagnosis. There were a series of things that happened which happened to align, to compound the sort of tragic events. Having said that, we recognise and can evidence that we have made improvements since we took over prison health care. It's stronger now than it was then. It's stronger. We've made further improvements since 2014, and since the sort of instances of Sean Lynch's self-harm. And I have no doubts and recognise we still have further improvements to make. It's an incredibly difficult environment. Ian has touched on some of the things which make that particularly difficult. That's compounded by the level of sort of staffing vacancies that we have. So there's a range of things that actually combine. All I can say, as I said in the opening statement, is we're absolutely committed to learn from this. Back almost to your previous question, which is being completely open to our own sort of errors or the failures in different bits of our system, so as we can improve the service and make it stronger. And I feel we have a duty to Mr. Lynch and other prisoners to do that.
Thank you very much.
Okay, Michaela Boyle.
Thank you, Chair. I'll be very brief. I don't have a question. It's just a comment I want to make. And I think, Elaine, you said earlier as nurse manager, I think it was a very good observation that you made. And I think this is key, and it echoes the need for prison reform. You did mention the fact that prisoners who are locked in their cells for long periods of time, they have no other outlet other than, access to drugs that are readily available within most of our prisons here. You said that it'll never be, the drug misuse will never be addressed until that's probably addressed. And I had been into Maghaberry Prison and met with some of the inmates in there, and they're saying the same. So I think that echoes the need for prison reform. I want to make another comment. Just Hugh, you did mention earlier that it's not a hospital; it's a treatment room in a landing, or what type of?
We have we've extended our treatment rooms into every house, and we've opened the Donard facility, which does a range of therapeutic interventions. It's not a 24/7. But the point I suppose I was making was we don't run a 24/7 inpatient unit in the way that you would within a hospital.
And the point I want to make is that the perception out there when we talk about a hospital, people think there is a hospital in Maghaberry, and whenever this news unfolded, people were saying, Joe Public was saying, how could this happen when there's a hospital in Maghaberry? So you need to change the language.
We're very clear, and we've gone to great lengths to try and make sure that it isn't called a hospital. And we even on one occasion had the senior members of the judiciary in, because they're obviously sitting in a different forum where they talk about the prison hospital. So we actually arranged a visit, took them around the facility, showed them that it was not a hospital. And that was why my opening comments today were around where the model of care it's important that we understand it's at the level we offer in the community. It's the equivalent to a health centre.
When you go to your GP centre, you go to a treatment room within your GP.
Yes, that's exactly
surgery. So it's just the use of language when we refer to hospitals. The public perception out there is people think that there's a hospital in Maghaberry.
I know we attempt to change that, so anything you can help us with in that regard would be very welcome.
I think those are just historic terminologies. I mean, prior to transfer, the nurses were called medics. The unit was called a hospital. It's just a terminology that was used. And I think you're absolutely right if there's anything that can be done to raise that awareness, because inbuilt in the assumption there are risks, and the assumption being that the individual could have access to something that's not currently there.
And again, going back to when we talk about families, for someone who goes in who's committed with mental health problems, there are families who think they're going to get better in there because there's a hospital in there, and they're going to be treated like they would be, if it was a hospital setting. So that's my comment.
Okay.
We certainly hope to offer at the same level they would get in the health centre, and I did say at the outset we have somewhere where we've extended services, including around the mental health and addictions. But I said in my opening comments, I think we could still do more. Also, just picking up your first comment in terms of the reform, I mean, I think we would our experience over the last couple of years is the prison service have worked very closely with us to try and they've had their reform programme, and certainly from our point of view, we see that cooperation at both a senior and an operational level to try and move to much more of a rehabilitative model. They cooperated and helped. And we're party to the development of the Donard Centre, the choirs, and some of the other initiatives. So, I would pay tribute to Sue McAllister, because she certainly has supported and helped us, and more recently Phil Ragg as well, and some of the other governors.
Yeah, because I've chair, sorry, not to elaborate, but I've also been in Maghaberry as chair of the Public Accounts Committee to see their education programme. And Elaine, you spoke about the mood of prisoners and the free, they're able to walk about free, and there's a sense of self-worth. That's it.
Okay, I'm very mindful that you've been here a very long time. I think everybody got a crack at it, asking questions. So again, thank you. Sorry, Trevor.
It's a very quick one.
Okay.
I just wanted to commend the choir initiative. Never thought of that. That's really a brilliant idea. Is there any notion that it might translate through to the adult prison as well?
There absolutely
Yeah,
is, and our staff in McGabbery, it's the same mental health service, they are really very keen.
Yeah.
See, and I think that is really where we need to focus, just to think through a wider range of alternatives and provisions. Hugh's absolutely right, that can't happen. That's a result of the partnership between. But the lovely thing about the choir is it's not just the patient-stroke prisoners who are singing, it's the staff as well. So our staff and the prison staff are on the stage with. And we've also linked that choir to a choir in community called Voice of Recovery, which is a choir which is for people who are recovering from addictions. And they reach into, and that provides an outreach. So we need to be thinking how we can get that to McGabbery.
And a big, in your comment about self-worth, I think one of the most powerful pieces about the choir is, and the feedback we get, I mean, and the results are impressive, but one of the things is that sense of self-worth and value in terms of being involved in it. I should give them a plug. They do sell their CD. It's somewhere between £5 and £10 if you want to make a contribution.
There's a music therapy trust out there that is very interested in this, and I don't know if you have any contact with them, but they're nodding. So.
Well, we have a choir master stroke who is absolutely excellent, and whether it's music therapy or arts therapy, it's that broader range of provision that we need to kind of stimulate further.
Okay.
I recently attended one of their performances. I think it was very much for Sue McAllister leaving around the middle of October in Hyde Bank, and it was really very powerful, very moving in terms of people who were standing up and singing had never done anything like that in public before, and you know, that sense of almost achievement, and it was very, very powerful.
And, I don't know who it was said that music hath charms to soothe the savage breast, but it's true, you know. And
but actually it's not just about music, they actually co-produce, so they are involved in writing poems about their experience, so actually it is a much wider range of creativity and therapy than just the choir.
no, it's great.
And it extends because out the prisoners that leave, actually on some of the performances now, that some of them they will come back in, and they're only allowed to do that providing they stay clean in terms of drugs and not obviously back in prison.
I must bring the curtain down on this. Okay. Listen, thank you very much. I know you've been there sitting there a long time, so thank you very much. We do appreciate it. And members, we all got a chance there to ask questions, and I was liberal with my time because it was such a big issue. I'm going to have to be more conservative in our time moving forward, so we are rushing for time here. Thank you very much for your attendance. Can I seek the views of members then on whether any further information is required from the South Eastern Health and Social Care Trust in relation to this report? Or is members content with regards to the question answering? Members content? Okay. Can I seek the agreement of members to send the copy of the Hansard of the oral evidence session to the Health Committee for information? Agreed. Can I also advise members that the Department has responded outlining the additional information the Northern Ireland Prison Service officials agreed to provide during the oral evidence session on the 6th of October. The response is at pages 186 to 190 of the meeting pack. Can I also seek the views of members on whether they are content with the information provided or whether further clarification is required. Can I just highlight, I think it was maybe Declan had raised this at the time, the Department has not provided the terms of reference for the internal investigation or indicated that there were no terms of reference. Therefore, the committee may wish to clarify whether terms of reference existed, and if not, request details of the instruction request given in relation to the internal investigation and what it should cover. That's just something that maybe we should be requesting of them. Members may also wish to consider whether a response regarding whether the investigation considered why an instruction was given on the night of the 4th of June to intervene and physically restrain Sean Lynch, but not on the 5th of June. I think we still could seek further clarification on that. Are members content with that, those actions? Yeah. Okay. Agenda item number 6 then, Criminal Justice Inspection Northern Ireland Report, Driving Change, Enforcement of Road Traffic Legislation in Northern Ireland, the evidence session with the SIGINI. Can I remind members that the committee agreed on the meeting of the 6th of October to schedule oral evidence sessions with the Chief Inspector and with departmental officials on the findings and recommendations of the Criminal Justice Inspection Northern Ireland Report on the Driving Change, Enforcement of Road Traffic Legislation in Northern Ireland. I advise members that the SIGINI inspectors will attend the meeting to outline the key findings and recommendations. Pages 221 to 276 of the meeting pack. Can I welcome Brendan McGuigan, Chief Inspector, and David McAnulty, Inspector of Criminal Justice Northern Ireland, to the meeting. I can only apologise for the length of time you had to wait. I know, I'm sure that we all have better things to do in regards to that. We were taking part in the session, you were not. So I can understand the frustration build up there. I can only apologise for that, Brendan. But without further ado, can I just advise you that this will be Hansarded? And without further ado, I'll ask you to lead off for us. Thank you.
Thank you very much indeed, Chair. And members of the committee, this is my first opportunity to speak to you about some of our reports. And I hope it's a long and fruitful relationship for both of us. Could I say right at the outset, I actually benefited from the inquiry that you've just had. As you know, I have a significant interest in prisons, and I have commented in the past on the relationship between the prison service and prison health. So I welcomed that. I thought that the questions that you were asking were the right questions, and I was very interested to hear those answers as well. So it wasn't wasted time for me, believe you me. It was extremely beneficial, so thank you. This is a report on road traffic enforcement in Northern Ireland. And the findings of this particular report were that the road network had become fundamental to modern living, and the three-pronged approach of engineering, education and enforcement should be kept in balance and under constant review. The number of people killed and seriously injured on Northern Ireland's roads remained unacceptably high for such a small jurisdiction, with some road users involved in persistent offending. This was particularly noticeable in relation to the offences of speeding, driving while under the influence of alcohol and or drugs, and mobile phone usage while driving. Inspectors found individual driver error continued to be the single major contributor to those killed or seriously injured on the roads in Northern Ireland. A general overview of the inspection findings really are in three areas. The first one related to cross-border cooperation and mutual recognition of legislation. 8 years on from our 2008 roads policing inspection, anticipated progress has not been made. We have not achieved the mutual recognition of penalty points, driving disqualification, and the lowering of drink-drive limits between Northern Ireland and the Republic of Ireland. Cross-border traffic continued to be a major concern for those on both sides of the border, particularly when visiting drivers travelling north or south in Ireland could flaunt the traffic laws in the opposite jurisdiction to where they lived with limited consequences. In October 2012, government ministers from both Northern Ireland and the Republic of Ireland agreed a timetable for full cross-border recognition of penalty points in both jurisdictions. This was to be achieved by December 2014. However, there were no working proposals or timetable in place to enable this to happen at the time of this inspection. Since the 1st of December 2014, the European Convention on Driving Disqualifications has been invalid between the United Kingdom and the Republic of Ireland, meaning that mutual recognition of disqualified drivers was also no longer possible. Despite both governments having committed in 2015 to amend legislation to ensure that mutual recognition of disqualified drivers continued, and signed a treaty to this effect on the 30th of October 2015, no progress was evident. Inspectors were concerned that in the absence of any forward momentum on the mutual recognition of disqualification and penalty points between the United Kingdom and the Republic of Ireland, an increased level of danger existed on the roads in Northern Ireland, which required urgent attention. Since the inspection was carried out, the United Kingdom has signalled its intention to leave the European Union by triggering Article 50 of the Lisbon Treaty. This impending change has the potential to create further issues in terms of the enforcement of road traffic legislation, particularly as Northern Ireland will be the only part of the United Kingdom to share a land border with another European Union country. In the second area on technology, inspectors identified that available technology was not being sufficiently utilised by law enforcement agencies. In 2008, we recommended that the Police Service of Northern Ireland upgrade and update its automatic number plate recognition strategy to reflect that of England and Wales and provide for its greater usage. In this report, inspectors found that the ANPR remained an underused resource that was not routinely used in or for day-to-day detection and enforcement activity. This was despite ANPR providing a ready source of information for all enforcement agencies, not just the PSNI. In comparison, inspectors found that extensive sections of the motorway network in England, Wales and Scotland were monitored, controlled and enforced smartly by remote technology. With reducing budgets and fewer police and other enforcement officers available to undertake enforcement activity, inspectors believe the wider use of ANPR across the road network in Northern Ireland could provide an automated enforcement system and help to ease many of the issues and resource pressures being faced by the PSNI and the Department for Infrastructure. Legislation allowed for the Department for Infrastructure to check heavy goods vehicles, buses, cars and taxis to ensure they were complying with the law with a view to improving public safety. Roadside enforcement of legislation required the use of various information databases. However, inspectors identified the development and use of upgraded roadside technology to support a joined-up, fully integrated central database would be of greater benefit to those tasked with enforcement activity. The establishment of such a resource would provide smoother, faster access to information, improve efficiency and support a more meaningful integrated approach. On the administration of road traffic legislation, inspectors identified that there was a compelling argument to develop an administrative solution for dealing with minor road traffic offences, which in turn would reduce the pressure on the magistrates' courts, the Public Prosecution Service and the PSNI. The use of police-led prosecutions in England within a road traffic court system demonstrated how traffic legislation cases could be dealt with efficiently. Inspectors observed the police-led prosecutions in operation in Norfolk and Essex and found that a dedicated traffic court to deal with guilty pleas for breaches of road traffic laws could deliver significant benefits. Court rates indicated most cases were dealt with without the need for defendants to attend, and around 2/3 of those who did attend pleaded guilty. The removal of traffic cases from magistrates' courts lists, which represents about at least 1/3 of all cases going through our magistrates' courts, had the benefit of freeing up both police and prosecution time and enabling the courts to focus on more serious cases and help reduce delay. A study undertaken of specialist courts in West Yorkshire in 2003 revealed the levels of cases withdrawn, discontinued, not serviced or failed fell from 85% to 1%. The national level in England at that time was 43%. If adopted in Northern Ireland, inspectors believe an administrative-led approach would centralise case management and expertise in road traffic law while providing clearer communications to defendants without the need for them to attend court. Dedicated court sittings could reduce time and costs by processing routine cases en masse. If implemented, some legislative changes would be required to allow another body or organisation other than the Public Prosecution Service to deal with road traffic offences. In conclusion, we have made 3 strategic recommendations which, if implemented, will support the aim of changing driver behaviour and potentially help save lives, whilst establishing a more efficient, effective enforcement system to improve road safety in the context of diminishing resources. Chair, I welcome any questions that members may have, and my colleague David McAnulty, who was the lead inspector on this work, will support me in responses.
Okay, Brendan, thank you very much. Straight into questions from me, because we are restricted with time and pressured. With regards to the driver disqualifications and the mutual penalty point system, whilst I have sympathy for that desired outcome, that will keep all the roads in either jurisdiction safer. Obviously, I can understand one of the reasons why it could not and has not been implemented yet, and that's down to the different legislative frameworks in the 2 jurisdictions. That's one of the rationale for it not being implemented to date. What's your take on that? Is it insurmountable? What would it take? And do both legislative frameworks have to merge in the same, not merge, but have the same penalty points system?
Well, Chair, I believe that politics is the art of the possible, and if there's a political will, a way will be found. The reality of this situation is, for as long as this continues, we have the ludicrous situation where drivers disqualified for very serious driving offences in the south of Ireland can drive in the north of Ireland, and vice versa. And how can that keep the public safe? So for me, this is a public safety issue, and we have evidence of other jurisdictions across Europe where actually they have achieved this very aim.
Would it be legally, well, I suppose, and you say anything is possible with legislators, but whilst it's down as 2 things, your driving disqualification, so you've been disqualified already. I can understand how that may well work out easier because it's clean cut. Now, you might be disqualified for different things. People can be disqualified, drink driving or just accumulation of points. But the fact that you have 2-point systems, which maybe have a different threshold for disqualification, is there something legally where if you go for a blanket ban if you're disqualified in 2 jurisdictions? Is there a legal loophole at the present time where if you did that, just say tomorrow, put legislation down, that someone may take a case to the European Court of Human Rights or something of that nature, the Supreme Court, with regards to, well, no, actually, whilst I'm disqualified in Dublin because I've accumulated so many points, actually, if I had committed the same offences in Northern Ireland, I would still be 2 points shy or 3 points shy of disqualification. Now, you can understand if you've done something horrific and you're disqualified, you can understand how you could well justify being disqualified up or down different jurisdictions. But when it's so close and you've just been disqualified and they don't read across neatly, so that if you were caught then in either or jurisdiction, it wouldn't be the same. You could well be driving legally if you were committing all those offences up north or south. So there is that anomaly.
Yes, Chair, there is indeed, but I believe that the courts in both jurisdictions are more than capable of listening to pleas of mitigation and in terms of setting the penalty accordingly. But we do have a situation, and we actually do have a situation at the minute where people have been disqualified for causing the deaths of other citizens. who are capable of driving in a neighbouring jurisdiction, and that for me is an intolerable situation. We would not countenance that in any other area of the criminal justice system, and yet here we have it on our roads policing situation, that actually this can occur. And for me, that should be a priority. You will see that, and I'm sure if you looked at the timetable where I had signalled to all of those that would have been involved that there was an urgency in dealing with this. And actually the time frame, although the report was published in September, the departments were well aware of my thinking around this, and I had put a timetable that actually we should be seeing progress by this December.
If progress was made, if tomorrow whatever legislative process was complete and the two legislative frameworks were aligned enough to make it work, let's say we go for the optimum, so every offence incurred the same penalty on both sides, points and convictions, same right across the board, both sides of the jurisdiction, the border. How do you future-proof that? How do you stop a campaign either in Northern Ireland or the Republic of Ireland for increased convictions or an increased sentence for a particular crime? And then how will that work? Yeah. With the treaty or with anything you've agreed, cross-jurisdictional?
Once again, I'm not a legislator, and I would stress that, and perhaps that question could better be framed to those that actually develop statute. But for me, I go back to my original comment around this, that this is an issue about public safety. This is about keeping people safe on the roads. We all use the roads. And the reality of it is that we have this anomaly at the minute that really we should have closed this door years ago, and here it is. We still haven't done it.
Moving on swiftly then to the issue about technology. Are you saying that we're not using the technology in the right ways or the right areas, or there's just not enough technology? Take very basic cameras. Are we talking that there's not enough cameras, or that we're not using the cameras in the right way?
I believe that you could use the cameras. I think we have a very good camera network in Northern Ireland. I think we could use it much more effectively. And so the principal aim of policing a number of years ago was denying criminals the use of the roads. Because the reality of it is that so much criminal activity and behaviour was also associated with driving on the road, so that people who were driving without licence and insurance could well have been driving in cars that were unfit to be on the road, could well have been involved in other sorts of criminal activity. And there was a series of initiatives over the years, joint operations which involved the Revenue and Customs, the Social Security Agency, the police, the Driver Vehicle Agency, which was really an attempt to take these sorts of vehicles off the road and actually deal with offending drivers, many of whom were persistent and were flaunting the law within Northern Ireland. So we could have used the technology much better, and in sharing that information and in following up on the fact that the ANPR system as it works will ping on cars that are untaxed and uninsured. And it may well be that in sharing that information with operational police officers, actually, you might be able to do something about it. You might be able to stop these individuals, to bring them before the courts, to ensure that they don't continue to use the road network. And in sharing that information more widely with other enforcement bodies, which would include the Driver Vehicle Agency, that they weren't just dependent on their roadside systems, camera systems. I think that you would develop that partnership approach to ensure that your enforcement activity was more effective.
Who actually has eyes on those cameras at the present time?
Well, it sits within Crime Operations Department, so they would primarily have the responsibility for monitoring them and I suppose dispersing the intelligence that would be coming from them.
And so are they really only dedicated or only looking towards vehicle crime, or do they look at all crime?
I would say that their priority is particular types of crime and probably the more serious crime. And of course, the system, as it operates in England, Wales and Scotland, would be contributing to national security as well. So there would be vehicles of interest, individuals that you know that might be travelling in particular vehicles that would be of significant intelligence benefits to the agencies charged with protecting the state.
So it's fair to say then that vehicle crime, and it's genuine, isn't one of the priorities for those people with eyes on?
Well, certainly our belief is that it isn't the number one priority.
But it could be shared to the.
But it could be shared, and I know I'm not saying that it would have its other uses as well, but actually, because of the infrastructure that we have in Northern Ireland, it could be used much more effectively, and I think could help deny a lot more criminal activity that's taking place on the roads.
Moving then quickly on to the court setting and the traffic court. Now, it's something that this committee is very, very interested in with regards to, well, the court restructuring. It's one of our priorities, how we do things better in the judicial system, quicker, slicker, smarter. So problem-solving courts is up there, right up there with that. We see this as a branch, if you like, of that, where you could be taking benefit not only from the actual specific offences that you're dealing with, which is the traffic one, but if you remove that into a specific setting, then you're not only dealing with it more efficiently there, you're also freeing up the court system in other places. So you'd have a knock-on, widespread effect, positive effect. I suppose there's always the proof of the pudding and the eating. Where do you see the savings being there, and how much of savings could be accounted for? And then where do you see the burden being placed? And how much of a burden compared to the savings?
Well, I probably have to say something about our situation in Northern Ireland and the time it takes to process cases through the criminal courts. And it's an issue that we have returned to on a number of occasions. And unfortunately, the situation hasn't improved. We take much longer than our neighbouring jurisdictions to process cases. Some of that is because, especially in the magistrates' courts, that a high proportion of the cases that go before the magistrates' court would be traffic related. Now, a lot of them are straightforward cases. You either have a driving licence or you don't. You're either insured or you don't. You either your lights were defective on your vehicle or they weren't. You were driving with baldy tyres. It could be a range of things, but actually they're relatively straightforward. But because they constitute quite a number of cases on the list of our magistrates' courts at the minute, then the cases that really do need to be pursued, the ones that are taking longer than they should do, don't get the attention that they deserve. That's the problem. And if you look at the figures, yes, traffic cases don't take as long as other criminal cases, but actually they're providing almost cover for sometimes the criminal cases. The fact that a magistrate or a district judge might have 100 cases to manage in a daily list, but actually out of that, and we have examined this over time, a substantial number of them could well be traffic-related offences, which are straightforward. But actually, what it does is it takes away the opportunity to really focus on the more difficult cases and those that are sitting in the system for far too long. The second thing is that, and I suppose in terms of the cost savings, it is that there's a process at the minute, and the report shows it clearly, that what happens is that officers detect offences, they start to produce prosecution files. Those prosecution files then go through a quality assurance process, and then they're transferred digitally through the Causeway Hub to the Public Prosecution Service. Prosecution Service will then examine that case file and then decide whether a prosecution is required or not. Well, what we're saying is actually for quite a number of these cases where it's clear that the motorist is prepared to plead guilty. In other words, they're accepting, look, I did wrong, I didn't have this, whatever. And if they want to enter a plea of mitigation, they're still free to do this. But actually, instead of sending it to the prosecution service, there would be a process that actually looks at this and says, right, let's push it through this more administrative process, which would include the service delivery of a letter that say, actually, this case is up in court on the 17th of November. And if you wish to appear on that occasion, you're more than willing to do so. Now, if you had indicated at an earlier stage, I'm fighting this, I don't agree with this, or actually the offences are involved with other offences, so it may well be thefts or burglaries or something like that, then all of those cases will still get transferred to the Public Prosecution Service. But what we found in England and Wales was this was a response to the pressures that the police and the Crown Prosecution Service and the courts were experiencing in England and Wales. And when we looked at the overall cost savings, they were considerable. Not only did it save time for police, it meant that prosecution lawyers, trained lawyers, were not having to look over these, forgive me, but quite straightforward and simple cases, which don't require the input of legally qualified persons. And actually, they could be processed through an administrative process and brought to a dedicated traffic court to be dealt with there. In England and Wales, they sought the prosecution charges, as indeed do we here in Northern Ireland, not between the prosecution service and the courts, but actually if any of the departments are bringing criminal cases, they'll seek reimbursement of the prosecution charges. And so the whole thing then became cost neutral. And not only that, in England and Wales, a substantial proportion of the monies received in the prosecution charges was actually sent back into road safety initiatives. And in my thinking around this was, here we have the Department of Infrastructure signalling to the executive that it was under considerable pressure to continue what is very effective advertising to try and reduce some of the persistent problems like speeding and mobile phone usage, drink driving usage. Actually, this money could help try and defray some of the expenses in those which are prime time and very expensive advertising campaigns, but very effective. And I'm sitting saying, yes, offenders should pay for this.
Can you be so bold as to put a figure on it with regards to money?
I couldn't really, but we do signal, what it costs to process these cases in England and Wales. David, would you?
Yes, we visited two main areas with Norfolk and Suffolk and Essex, and what we saw there was a very administrative system where you had a lay presenter turned up to court, basically outlined the facts of the case, and then the court decided on the outcome. And at that point, they applied for costs. I think the average for the costs for 2014 and 15 was around £40 per case received back. Now, they may have applied for more costs depending on the area of the region, but that's the amount they actually got back. If we equate that to what's happening in Northern Ireland, for the entire process moves from the police service to the prosecution, and it's that layer that we focused on. It's the layer removal and the cost therein that we were seeking to remove. As Brendan rightly says, this turned out not only to be cost neutral, but the benefits to not only the long-term court system, but the immediate it provides a system for those who are in breach of the legislation to have a certainty that their cases are going to be dealt with by experts, and they were safe in the knowledge that it was going to be dealt with in an efficient and quick manner. But that had to the attributed effect that those on the other side who are driving the roads were kept safe.
Yeah, but with regards to that layer of transfer from the police who enforces and fines, detects the crime, to the PPS who actually goes through the court process then at that high level of expert, is there costings or savings for that transfer? The specific link that you're trying to remove to make it more procedural?
We had done some initial analysis of that. Now, it would require further analysis with our prosecution colleagues, and something we will re-examine following our recommendations. We saw that the unit cost per case was substantially less than that of the prosecution team. However, the prosecution may have a different viewpoint on that.
Yeah. Okay. Pam Cameron?
Thank you. Thanks very much for a useful report. Chair's covered most of my queries. I know from previous 3 years on Environment Committee, we were continually asking questions in the Chamber around the mutual recognition of penalty points. I don't recall anybody talking about disqualified drivers. That really is quite scary. The idea, we understand that points don't carry back and forth, but I hadn't actually thought of disqualified drivers. But I mean, the potential there, I suppose, is somebody who's actually living in the Republic and is disqualified could move to Northern Ireland and live here and drive away. As you say, and they may actually have been disqualified for very serious offences. I presume that there's no protection from disqualified drivers coming from anywhere else in the world.
Well, essentially, since 2014, since the mutual recognition element was removed between the UK and the legislative in the UK and within European directives, they were removed from that actual body within the European directives. It meant that anybody from outside of the UK who were driving in the UK could be disqualified and drive without any adverse effects, as it were. There were, in 2015, as we have said, there were moves to have reciprocal legislation in place, but we have found no evidence of any movement towards it, as you've pointed out.
I think, Chair, also that this follows on from that previous piece of work, which looked particularly at the very commendable efforts, both sides of the border, to try and deal with what was seen as high levels of road deaths and bad driving, really, on both sides of the border, and that actually people from either jurisdiction just seemed to be taking carte blanche when they moved into another jurisdiction. So, in many ways, well, it may not be explicit so much in this particular report, but in the last one, it was, look, there was a direction of travel we seemed to be going at, and then to suddenly review it, or to review it when we did, and find actually it had just disappeared. The energy around this and desire and will that appeared to be present back when we did the first inspection had just evaporated.
With regard to the use of technology, that's, technical difficulties, I think, was always what was quoted as being the reason behind not having the mutual recognition of penalty points, and they're continuing to work on it. I'm not hearing anything to give me any confidence that that's actually going anywhere at all, or that it was actually progressing. The matter is, just for clarity, is that your opinion, that actually we're not actually going anywhere on the issue, that it's just pure stalemate?
we could find no real evidence of progression around this, and the reports were circulated for factual accuracy, and there was an opportunity for departments and for the agencies to actually highlight to us where our assessment was wrong. So in the absence of that, unfortunately, you're left with my view on this, but nobody has put me right on it.
Okay, thank you. And just finally, on the courts issue, I know the chair was kind of pressing you around the cost, so I think that's very interesting. £40 in England per case.
On average.
On average, but I mean, if you were, well, I can't imagine us coming anywhere near close to such a small figure here for any traffic offence that's going through court. I mean, I can't imagine how much it costs, but I imagine it will be lots of knots on it.
Chair, as I say, I've 12 years in operation. We've been looking at the issue of avoidable delay in Northern Ireland. I really welcome the focus of the committee here in terms of trying to support the whole concept of problem-solving courts. And there's no doubt that there will be issues that continually return within our courts, and I welcome that. But actually, the primary issue here is around the unacceptable levels of avoidable delay in Northern Ireland, which have remained stubbornly unacceptable. And what I'm saying is there are now fewer cases being processed through our criminal courts, and yet the time is still the same. So there's a cultural issue here that actually needs to be challenged. And what I'm saying is, well, actually, here is evidence, very clear evidence, in a neighbouring jurisdiction where actually they have adopted a different approach, and it's delivered significant efficiencies and savings.
Hard to argue with that. And of course, there's nothing more stressful than waiting for something and waiting to go through a court case. No matter what side of that case you're on, is incredibly stressful, and never mind costly. So, I mean, if we did have the ideal problem-solving courts in place, who's the loser? Who's going to object to this?
I couldn't see that anyone would. I have the utmost respect for our criminal justice system and the ability to actually ensure that justice is delivered in as best as it possibly can. But this was very clearly an initiative that we became aware of, and it is very clear that when organisations are facing significant pressures, they have to come up with solutions to try and deal with the fact that their budgets are reducing. And just in Northern Ireland, I'm just concerned that actually with falling numbers of cases going through the courts, I'm not seeing changes to and reductions in the amount of time that it takes to process these. What I think would change here is that if you had fewer cases before the magistrates' courts at the minute, those will be the cases that actually need to be paid attention to, so that actually when people are seeking adjournments, and sometimes lengthy adjournments, that actually the judge, presiding judge, magistrate has the time to actually put the people, either the defence or prosecution, right over it in terms of whether the adjournment is actually appropriate or not. Because we know that if it's not, then it is the knock-on effect on victims and on witnesses, which are the mainstay of our criminal justice process, that their confidence is reduced. So what I'm saying is, look, let's take even more cases out of the process. Let's put it into an administrative process which doesn't deny anybody their fundamental rights, but actually we find an administrative way of dealing with these, what are seen as straightforward, low-level issues, summary offences, summary traffic offences, which represent a significant number of cases that populate our courts at the minute. Take them out of that, they're still dealt with through the courts, but actually take them out of this process between the police and prosecution, so that actually they move much more swiftly. And in moving much more swiftly, you're dealing with the persistent offenders, that actually they're having to respond to their responsibilities before the court much quicker than what they are at the minute.
And finally for me, but obviously we're looking at road safety here, but if you translate to other areas of crime, and I'm thinking in particular of, if we had drugs courts or domestic violence courts, surely, the prosecution levels would be more successful if the timelines were brought down for all these cases. Because obviously the longer time, I'm thinking domestic violence in particular, the longer cases turn on, the more likelihood of dropouts. There's going to be, if something is going to impact on lives for months and years, the temptation to drop out is going to be all too great. And
absolutely, and that's what happens in many cases, that victims simply lose the will to proceed with the case.
Thank you. Okay, Trevor Lunn.
Yeah, thanks, Chair. Just to go back to the very serious disqualification situations, Brendan, you mentioned at the start. Now, if somebody attracts, let's say, a 12-month ban in Northern Ireland, I know there's people out there who think that if they have an address, perhaps in the Republic, that they can drive down there. That's not really the case. I mean, they can physically drive. It doesn't mean they're driving legally. If they're going to use an address in the Republic and a car registered in the Republic, well, then they need to have insurance taken out in the Republic of Ireland, and they have to make a declaration that they have never been disqualified, or else reveal what their disqualification was. It doesn't matter if it happened in Timbuktu, you've still got to declare it. So I've come across this in my previous existence. People think that you can just cross the border and drive with impunity. In fact, you can't. But so the things that you're suggesting here certainly would go quite a way towards dealing with that situation. But there's other wrinkles to it. They could losing my thread here. Even in terms of the recognition, and the police can tell at the moment if a car is insured just by popping it up on their screen. It doesn't say if the driver is insured. It's just is there insurance in that vehicle. And even if the car wasn't insured, it's quite possible that the driver could still be driving it legally if he has insurance in another car, which gives him driving other cars. He's got third-party cover. So it's not simple, but I can't help thinking that in terms of a structure, it couldn't be that complicated, and it shouldn't have taken 8 years to try and sort it out. It's one island, an all-Ireland approach. I don't know what's happened to our north-south bodies, but they should be able to deal with such a relatively simple situation.
I don't disagree with any of that at all, and I suppose from our perspective, when we were looking at this issue, thankfully, as a result of our normalisation of our society, the reality of it is this is where our citizens are dying. It's on our roads.
Yeah.
And, anything that we can do to make them safer should be a priority for us. And I just think that sometimes people tend to forget that. When we see the figures and we say that's terrible, actually when you start to look at the numbers, and every fatal collision is avoidable, every one of them. Yeah. So we should be doing everything that we possibly can to keep our citizens safe on what is a network that the vast majority of us use on a daily basis.
Well, just to confirm the point for the record, if you're disqualified from driving anywhere in the world and you attempt to take out insurance, let's say in Northern Ireland, and you don't declare that, you must declare it. If you don't, you're not properly insured. You're not insured at all. In fact, you might as well drive without insurance, frankly. And almost paying the insurance is a waste of money. I shouldn't have said that, but it's a fact. It's worthless. Doesn't matter where the disqualification was. I driver from Estonia. One time came to live here, insisted he could take out insurance, but he had a band in Estonia, which I believe was quite hard to get actually, and couldn't get him cover. I have no doubt that he got cover.
Okay, Alex Abbott.
Yes. So I understand where we are in mutual recognition of penalty points, that the matter seems to have got stuck somewhere over the last period of time. Although I have a sense that at an official level, they think that the mutual recognition of penalty points is too hard to do, and that might be not just the thinking up here, but also the thinking in Dublin. I don't agree with that thinking wherever it might be, but I have a sense that that's what they really think. But the position with respect to mutual recognition of driving disqualifications, just to confirm, so there was mutual recognition of driving disqualifications between Ireland, Britain and Northern Ireland.
Yes.
And then that lapsed.
Yes.
But there's now a treaty between Britain and Ireland that allows that to be activated again. Is that the case?
Well, in 2015, they had set in motion moves to ensure that both sides legislation was going to be in place, but that didn't go anywhere.
But legislation in London and in the Oireachtas, is that right?
Yes.
Yes.
So is it the case that the northern parties are leaving it to London to take forward the action in this matter? Because previously the mutual recognition of driving disqualifications was between London and Dublin, is that right? Yeah. And you can identify no action being taken in London in that regard. Is there anything, were you able to identify any representations from Belfast to London to encourage London to get this moving?
Well, once again, Chair, when you produce reports and you present them for factual accuracy and those go to the relevant departments, I'm expecting them to challenge me and say, well, no, actually you're wrong there. Here's the evidence. Here's where we are with this particular situation. Actually, we couldn't find any. And there's no pushback at all from any of the departments. So
I'm sure we'll hear imminently a response to all of that.
And just one point of clarification. Recently, there has been moves across Europe to amalgamate the recognition of points, which is supposed to be in place by 2017, and some member states have already agreed it between member states, but to make recognition in anticipation of this new European directive.
Right. Well, I wasn't
So it is
aware
possible.
of that directive, so I'd like to see that, Chair, where what the directive says and where it is now in place. In relation to technology, I agree with what you're saying, but I suspect that's all going to get caught up in the Brexit negotiation in terms of what some think a border will look like on this island. And in respect to the courts, I reserve a position on that in the administrative scheme. Like, dealing with these issues has to be done through the prism of the issue of policing and reform of policing and criminal justice in Northern Ireland over the last 15 years. And therefore, I'd want to work that through a bit more before I'd say that that's the right thing to do.
And Chair, although we refer to police-led prosecutions, for me it could be an administrative team provided by the prosecution service. I would have no issues about it, but it's this process of transfer from the police to the prosecution service, where it may sit for some time before a lawyer has the time, because of the other number of cases that they may have to deal with, before they can get looking at it, and then the process then to get it listed and get somebody into court to respond to these issues. What they've done, in my view, in England and Wales, is stripped out unnecessary layers of bureaucracy. They've saved an absolute fortune and taken considerable pressure off the Crown Prosecution Service in England and Wales and the police.
That you, Alex?
Yep.
Just on one of the points Alex raised with regards to the UK dimension, obviously there's a treaty, obviously not teaching anybody to suck eggs in any shape or form. The new treaty is between the UK and Ireland in that regard, but there was a closure of a loophole in the Criminal Justice and Courts Act 2015, which basically meant if you were a UK citizen and you happened to get disqualified down south, there was a loophole there whereby you couldn't claim residency. They have the disqualification there and then move back up to the UK and then drive on as normal. There was a loophole closed there in that regard. That's not the same as having a mutual. I understand that, but there have been moves in that regard, or working towards. Is that recognised by yourselves as having?
I think the overall difficulty is we try to look at it at a global level across. We looked where we were in 2008 and what progress had been made since the last road policing and the difficulties with drivers driving south and north in Ireland.
Right.
So if you look at it globally, the issue still remains. The penalty points, disqualification presents a significant risk to the road users, and that was right at the front of our minds. So there may have been some movements in certain aspects, but globally looking at it, just for us there wasn't significant progress.
Okay, Roy Beggs.
Yeah, the issue of penalty points, I take it this is a particular issue in the border areas where people think if they're in the other jurisdiction, well, I can't take any penalty points, I can drive whatever way I want. Is that what happens?
Well, I don't think it's just in the border region. Unfortunately, I have been travelling to Dublin and I've seen many registrations that aren't coming from border regions passing me, flying down. And,
on the motorways as well?
On the motorways, impervious to, and vice versa. It's not just the border regions. In the southern counties that would be speeding in the north. It's just this belief that they can do it.
Yeah. Mention was made that some European countries have mutual recognition, so it is possible. And can you name those areas where that's working already?
This is just something that's recently, very, very recently happened. It's not actually been enacted as yet, but it's something they're working towards in 2017.
Obviously, both jurisdictions have completely separate laws and maybe point system, but equally in terms of our university entrance and academic qualifications, there's been a mutual recognition system and agreed your A levels worth so many points. Is that all that is needed? That they agree a mutual points recognition system?
Absolutely, Chair, and the fact that it will go before a judge for a final decision as to whether the licence is taken away from somebody as a result of the accrual of a certain number of points, and that's the opportunity for pleas of mitigation, which still occur here. Despite the fact that somebody may have put it up over the 12 penalty points, there will be pleas of mitigation heard by the courts and decisions made accordingly. So I didn't see any issues with that, to be honest with you.
I think as a committee we have to pursue this issue further. The mutual, through the number plate recognition system then, can you give a bit more detail of an example of how the tool can be used, that it's not being used? I didn't quite grasp of some of the tricks that we're missing that are applicable and are working elsewhere.
And certainly in England, Wales and Scotland, the ANPR system, as I said, can regulate and improve enforcement activity across a range of roads, wherever roads that they're on. But it takes you to be looking at the cameras and looking at the right issues and doing that on a constant basis. But if your focus is on merely one particular issue, or on a small number of individuals or vehicles that are of specific interest from a security dimension, then you're missing out on the fact that actually there are people driving on our roads committing crime that actually could be pursued. But if you're not picking that up on a regular basis, then for me, then you're missing out on a wonderful opportunity, and especially for sharing information with the other enforcement bodies, which includes the DVA, HMRC, and I suppose picking up the spirit of the executive at the minute, which is looking towards a more outcome-based approach to the way departments work with each other. Here's a wonderful example that there is a tool available that provides information across departments that can actually improve enforcement activity and keep our roads safer.
Okay, moving on to the traffic courts system then. I want to press you, just what are your, I realise that there's a huge health warning and there's still further calculations needed, but what is significant savings you're talking about? What percentage do you think is easily achievable, safely achievable by moving to the new system?
Well, I suppose we haven't done the figure work on it. We have, but we haven't agreed it with others, so we didn't publish it.
But there's an example in Norfolk. You've said that they have something. What have they achieved there?
They have achieved considerable savings.
What were we talking about?
Well, if you look at what Northlands and Suffolk, the number of cases per year was 12,399 traffic cases.
Which is almost comparable to what we do here in Northern Ireland.
Very similar, and the region was very similar, spread out by the central urban area and a lot of rural districts as well. Their average cost received per case for them was £37.26. This is in 2014 to 2015. So the average cost received per case was estimated at £37.26, and then the unit cost per case that they worked out and fed it to me was £10.32 per case. So
if I £10 per case, 12,000 cases, it's costing them £120,000 a year to manage 12,000 cases.
Yeah. Well,
and that's, you say that's about 2/3 of the cases going to the equivalent of our magistrates' courts.
Well, it's just over a third of our cases going through the magistrates. A third of our cases going through the magistrates' court. And I mean, we have produced reports in the past that have talked about the cost of processing cases through our criminal justice system in Northern Ireland, which is still extremely high.
I actually asked the question, and there are over 10,000 cases in Northern Ireland where someone pleads guilty. So there's a very significant number which could automatically, if people wish that the transfers and be dealt with speedily, it could move there. But the court has said they've no idea what it costs. It's too expensive to calculate how much the current system does. Why is our court system so slow at changing and bringing in better mechanisms to improve justice?
Well, to be fair, I'm not being critical of the court service, because I think that they have, in my view, they've initiated some very important initiatives in terms of processing of cases through their courts, etc. But the reality of it, the reality of it is that we have a system. And I haven't seen that system change dramatically at all. I haven't seen any peace dividend across the criminal justice system that we may have expected to have found. That actually the system which expanded to deal with our troubles and during the times of the troubles actually hasn't contracted in the way that you would expect. Prison numbers actually are higher now than what they were at the time of the release of prisoners under the Good Friday Agreement. I don't see any change in the courts. The police service has reduced in numbers. But I would try and watch and see what's happening in other jurisdictions, because we don't have to reinvent the wheel. And I'm not saying that you have to adopt everything that's initiated in other jurisdictions, but what it's very clear to me is that the justice system in England and Wales, was under significant pressures as a result of transfers of money, and I don't disagree with this, to other areas, to health and education. And so they had to find alternative ways of dealing with what were essentially low-level cases where there was no disputes about it, which were still decided by a judge, but actually you could save a significant amount of money. In Northern Ireland, we haven't seen that dividend. I haven't seen the contraction of the justice system, other than the size of the police force. We still have 3 functioning prisons in Northern Ireland, and prison population, while it's down at the minute, is still, in my view, higher than it needs to be.
Okay, thank you.
Okay, Michaela Boyd.
Yeah, thank you, Chair. I'm glad you clarified that, Brendan, that it's not just in the border areas. I live in Strabane, less than a mile from Lifford, and but I'm well aware of the catch me if you can scenarios.
you know, and I think that's what you're trying to curb.
Absolutely.
Yeah. Just in terms of recommendation two, making it easy accessible for roadside enforcement staff. And I do know in the south, Garda, Síochána can, if there's a traffic offence committed and you're stopped, there is an on-the-spot penalty. You'll be aware of that. The concern, I mean, I've heard it before because I live quite close to the border. Complaints about that type of enforcement, roadside enforcement, and I mean, I don't know how factual this is, but I've heard of scenarios where Garda Síochána actually following people to the ATMs to release a payment to, you know, and that's what I hear. So I don't know how factual it is, but I'm just putting it out there. So I would have a concern in relation to that, how that would be policed, just if you know where I'm coming from. Yeah. But I do hear the message around road safety, and I think that's key in all of this, regardless of how it's played out. So that's the only comment that I wanted to make just about that. There is a perception out there that on roadside enforcement could lead to, you know, people being charged extortionate amount of money for offences committed on the spot.
I'm not sure if you can do an inspection
No.
on that, Brennan.
No, well, my experience, certainly in Northern Ireland, the only time that people would have been taken to an ATM might well have been to allow them to provide a surety for their release on bail, and it was probably it was taking them to the cash dispenser so that they could hand over the money, so that would be held to ensure that they turned up in court or whatever again, but no, our system doesn't operate that way. No.
Okay, Claire Bailey.
So just a wee quick one on the back of what you were saying there, Michaela. I mean, am I right in saying that we do have on-the-spot fines with police? You know,
Yes, but we don't take the money.
No, you don't drive you to the cash machine, no. But they can issue fines and penalty points, and then you present to the police station.
Absolutely.
Yeah.
Yes, we do have that system in place. It's for a number of offences, but they're a relatively small number of offences.
Okay, finished. Just to follow up a couple of those questions, they're very, very important, and I want to tie them all up. You talked about the European scenario, the global effect, and whilst you can see the common sense in this, cross-jurisdictional between North and South, you can also see it Europe-wide and everywhere, because you're protecting your own state or jurisdiction, if you like, by the very fact that you'd want to add that agreement or have a treaty in place, because you don't want lorry drivers from France, Spain, Italy, wherever, being able to use the roads in a different part of Europe, or travelling anywhere in a car. So you can understand how you would want that, but that's a relatively new thing, but it's going to be coming in. What impediments are there at the present time on that? Is it just the different layers and different frameworks of legislation?
Would this be between, for clarification, between Northern Ireland and the Republic of Ireland, or is this across Europe, the difficulties that they've had? Mm-hmm. I've only looked at briefly the recent changes and the recent proposed legislative changes.
Yes.
And there were concerns, as you pointed out, that, say, over in Europe it is a bigger problem because you have vehicles, heavy goods vehicles moving from Spain to France, right up to Germany. So it's a significant, much more significant issue for them.
But is there a will to try and resolve it?
Some countries, as far as I'm aware, have already adopted the changes prior to the directive being enforced in 2017.
But there is a European directive to go that way.
So it is possible.
Right, okay. So is there, do you know, and I know this isn't specific to the report, but do you know, is there a same problem with regards to the risk and the same awareness between Dover and Calais link? You know, is England and France having discussions in the same guise as Northern Ireland and Republic would have? Because obviously you can imagine that the Channel Tunnel and everything else, they would have the same problem.
Yes, but it's the exact same issue. I don't know, but I would imagine that as part of the, as it were, Brexit, and I'm sure this must form at some point in the future part of the negotiations.
Yeah. I'm going to challenge you, because I'm not the type of guy, Brennan, but let me just preface that by saying that I understand the risk, and I understand why we would all naturally go towards trying to make our roads safer. But you keep mentioning safety of our road users and the deaths on our roads, and you talked about, you know, post-troubles, you know, or people are dying on our roads. They are. But how many of them can you account for a driver that should be disqualified? Because there's risk in everything. We can walk out here today and there's risk. We walk, we drive, we ride, we do everything. There's a risk. So it's not good enough just to say there's a risk, we should do something. We have to measure risk and then manage it. And how big a risk is this?
Well, I think, Chair, you're probably like most of the rest of us driving on the road, and you'll see some lunatic driving behaviour. And you look at it and you say, you know, somebody needs to speak to that individual, or somebody. And so for me, you know, I could turn that around and say, how many children didn't need to die if their driving behaviour had been brought to their attention, if it were a salutary lesson around penalty points, or indeed if they appeared in court for dangerous or careless driving. And that's my issue around this, is it's happening all the time. Or if we're seeing a mobile phone user on one occasion who's using the phone while they're driving, or a lorry driver, and you know, being able to bring that to that individual's attention could well ensure that they don't cause a fatal accident in the future. Yeah, that's all I'm saying.
We all drive on a road and we all say that boy should be banned, that boy should be disqualified.
Yes.
It's not necessarily that he is disqualified in our jurisdiction. So have we done numbers? Have you looked at the numbers of actually and remember, we're not talking about numbers, we're talking about lives that have been lost. But out of those lives that have been lost, can we put a figure on how many were killed by a person who was disqualified in our jurisdiction?
Well, the Police Service in Northern Ireland carried all surveys of all and carried data analysis of the causes of death. So they would be in a position to answer that directly.
But you can't.
It's not something we looked at specifically. We saw that this was a significant issue with no progress, and it was such a serious issue for us.
I suppose that's what I'm trying to ask. I'm trying to ask, is it a significant issue? Because if we can say that no one has been killed on our roads in the last 5 years by someone who should have been disqualified, well then we could argue, well look, should it not be better focusing on people who are driving in this jurisdiction with no insurance?
Well, hopefully, Chair, they'll be doing both things. Yes. But you know, it just because of the amount of traffic travelling into both jurisdictions, and I suppose observing the driving. My background was in policing, and looking at the way people behave on the roads. It just appeared to me that it was the common sense conclusion to all of that, that actually, you know, that sort of driving behaviour could well end in fatality.
Yes, but what we can't do is put a figure on it as to say how great a risk it is. And whilst I know, you could argue, and I'm being devil's advocate here, of course, you could argue that somebody disqualified in the south would drive more carefully in the north.
Well, Chair, unfortunately, that's not what you see if you're travelling on the roads on a daily basis. And if you're paying attention to it, it's, you know, sometimes you're travelling at 60 miles an hour, you're obeying the speed limit, and somebody flies past you, and you look at the plates and you realise it's somebody from another jurisdiction, and that happens both sides of the border.
Yeah, but you can't then say that that person is a disqualified driver and he shouldn't be driving. And what I'm saying is, does he pose a greater risk because he's in a different jurisdiction? I suppose that's a good enough question. Is he posing a different or a greater risk because he's from a jurisdiction?
Well, it certainly would be if they were likely to get 3 penalty points you know, as a result of their driving, of a northern driver driving in the south or a southern driver driving in the north, that actually they weren't immune to prosecution, that they didn't have the option to flagrantly disregard the law, that there were consequences. We expect drivers to act responsibly, and there are consequences for not doing it. If there are no consequences, then small wonder that people flaunt the law.
Yeah. Okay. You talked about, I think it was Alex's question to David, you talked about having done the figure work with regards to costs, but not publishing it because you couldn't get agreement. Can you elaborate what you actually mean by that? Who didn't agree with you?
Well, what we looked at was the number of cases go through Northern Ireland, the number of cases go through Essex, the number of cases go through Norris and Suffolk, and saw there's a similar amount. And we worked out how many people stand up in court in each of the jurisdictions. And then it's a simple matter of dividing that number of cases with that number of staff and how much they get paid. It's a very, very basic calculation. And you know, that's where there's some of the difficulty lies, because maybe we oversimplified it. But for us, it was a simple matter. That's how many people are prosecuting that case. In that jurisdiction, you have 4 people in Norfolk and Suffolk. They're getting paid £20,000, £18,000 a year, probably less than that. And it's a simple numerical sum as that. Now, there are some financial issues that there were ongoing discussions with those who are responsible for prosecution of the cases. Put it like that.
Okay.
Which would need to be ironed out.
Okay. Right, no further questions. Thank you very much. And I do apologise again for your wait at the start, but again, another very good session, so thank you very much for your time.
Thank you, Chair. Thank you.
Okay, was there any further questions out of that, or are you happy enough to leave it at that point? Of course, this is a rolling progress for us. It's one of our priorities, or one of, and we have said that we'd do a piece of work on this with regards to the traffic side of things. Okay, moving on then, agenda item number 7, Criminal Justice Inspection on our report driving change, evidence sessions from the officials from the department. I advise members that officials will now attend to outline their response to the findings and recommendations of the Sugini report. Additional relevant papers are pages 278 to 283 of the meeting pack. Can I welcome to the committee Ronnie Armour, Chief Executive of the Northern Ireland Courts and Tribunal Service, Liz Locker, Director of Road Safety and Vehicle Registration, Department of Infrastructure, James Hutchison, Compliance and Enforcement Director, Driver and Vehicle Agency, Department of Infrastructure, and Diane Pennington, Chief Inspector of Road Policing, PSNI, to the meeting. You're all very welcome. Can I advise you all that the session will be recorded by Hansard and the transcript will be published on the committee web page. So again, thank you very much for coming. I do apologise for the length of wait you've had to endure. You've of course been here from the very start. I noticed that straight on, and you're the last to go, so please accept my apologies, all of you, for that. You'll understand that there's some serious issues and presentations to be had. So, but Ronnie, without further ado, I'll hand over to you. Thank you.
Thank you, Chair. I'll try and keep the introductory remarks brief. I'm grateful for the opportunity to discuss the Criminal Justice Inspectorate report on the enforcement of road traffic legislation with the committee today. Our statutory and strategic recommendations of the report cut across the responsibilities of the Department of Justice, the Department for Infrastructure and a number of agencies. I'm grateful to my colleagues for joining me today. They lead on a number of the recommendations and will deal with some of your questions on those. By way of introductory comment, the Department's welcome the report, which contains 3 strategic and 2 operational recommendations. Our strategic recommendation is in 2 parts and focuses on the need for the Department of Justice and the Department for Infrastructure, along with Road Safety Partnership, to advocate the mutual recognition of driving disqualifications with the Republic of Ireland, with the aim of achieving compliance by the end of 2016. Secondly, the recommendation indicates that we should develop an action plan for the mutual recognition of penalty points. As outlined in the Department's letter, which was considered by the committee last week, and the briefing paper that we have submitted to the committee today in advance of our appearance, The mutual recognition of disqualifications has been in place before the UK withdrew from the EU justice measures in December 2014. To reinstate the earlier position, a new treaty between the two states and new primary legislation in both the UK and Ireland is required. The treaty was signed and the new UK-wide legislation was made last year. However, the legislative process in Ireland is not yet complete. Reciprocal provisions were introduced in the Road Safety Bill in January of this year, but that bill has not yet completed its legislative process in the Republic. The latest indications from colleagues in Dublin are that it may be the spring of 2017 before the bill is finalised, at which stage the two jurisdictions will be able to proceed with implementation. Turning to the recommendation in relation to mutual recognition of penalty points, the committee will wish to note that that is proving somewhat more difficult to achieve. A steering group chaired by the Department for Infrastructure has been established, and that group is currently considering the need for legislative reform. In terms of the strategic recommendation 2, which focuses on the expansion of the use of automatic number plate recognition and the need for a new integrated database system, liaison is ongoing between the PSNI, the DVA and their partner agencies, and my colleagues will be able to provide you with more information in relation to that work. Thirdly, the third recommendation indicates that there should be a road traffic prosecutions team and a centralised traffic court in Northern Ireland, and this is a recommendation the Department of Justice welcomes. In summary, the recommendation aims to take volume cases which would typically plead out on the first or second court appearance and deal with them separately to free up time in the Magistrates' Court and reduce delay, as the Chief Inspector has indicated. The report highlights the work undertaken by police-led prosecution teams in 2 areas in England and recommends a similar model be adopted here. The Department of Justice, as I say, welcomes the recommendation and will shortly establish a cross-agency group to undertake a scoping exercise as suggested by SIGINI, and we'll be happy to update the committee further when that work is undertaken.
Okay, thank you very much, Ronnie, for your presentation. Very clear and concise. Thank you. I appreciate that. Straight on to questions. Whilst I was at you would have heard me questioning the SIGINI in regards to the reasons and rationale why we haven't got to a point where it's mutual recognition of penalty points and disqualification. What's your take on it?
Probably best if I handle that, Chair. I mean, the mutual recognition of driving disqualification and the mutual recognition of penalty points are actually quite separate issues with very different issues, so I'll deal with them separately. In terms of driving disqualification, the Minister's very supportive of mutual recognition. It's a clear road safety issue. Yes, it is. It would be obviously better if somebody who was banned in south of the border was also banned from driving in the north, notwithstanding Mr Lund's comments about insurance. The Department for Infrastructure and the Minister for Infrastructure has no legislative role in this, so the Minister has said that he will continue to notice support for the policy and he's happy to advocate the policy position regarding MRDD at the North-South Ministerial Council. As Ronnie said, our understanding is that because of the slower progress in Ireland, it's going to be spring of 2017 before that's in place. It is something that's needed. I mean, some of the other questions that you had raised with the previous, with CJI, there is, for example, no treaty in place between England and France, between Britain and France, so this would be a problem there as well, but we are, as I say, hopeful that we will have all measures in place for cross-border.
Sorry, just before you leave that,
yeah.
When you mean cross-border, do you mean that it will be between Republic of Ireland and the whole of the UK, or is it just Republic of Ireland and Northern Ireland?
Sorry, between the Republic of Ireland and the whole of the UK.
Yeah, okay.
So it will be between the 2 member states.
Yes.
Okay. Penalty points is a different issue, and it is something that, again, the Minister is very keen to see this go forward. It seems absurd that we cannot take driving convictions or penalty points in one jurisdiction and record them in the other jurisdiction. There should be a process where we can tot up the points to make sure that poor driving is being recognised across both jurisdictions, and this has been a particular problem in the border areas because there are a number of examples. Now, we don't have clear evidence, but we have anecdotal evidence where we know that people are picking up points in one jurisdiction that aren't coming through into the other. When we first started this back in 2011, we assumed that it was a legislative problem and we could solve it through legislation. And we set out to scope it. And we have solved jointly. We have, Mr. Atwood said that he considered that officials thought this was a difficult problem and it was maybe too difficult for officials, or officials saw it as too difficult. It is difficult. But at the moment, I thought you were going to blame a previous minister there. Certainly not. At the moment, it is. It is difficult. We have resolved a number of issues, but there are some real complex issues out there. And what we've discovered is the complex issues aren't actually the legislative issues. The complex issues are the operational ones. I'll give you an example of the issue that we're actually dealing with at the moment. It's around the service of summons, and it is particularly difficult for us to resolve at the moment. Irish law, it's quite clear that postal summons are acceptable. However, what we're discovering is that judges in the courts in the Republic won't accept the service of those summons. So essentially, we're getting a situation whereby if a driver in the north is summoned, if they ignore all the paperwork they receive, because they are not then presenting themselves in court, they're getting away with it. So what we've done to try and look at this is we've taken a number of followed through a number of pilot cases. We've taken 65 cases in the north and followed them through the system to see what happens to them and where they fall out of the system, so we can try and plug the holes. We've just completed that and we're just analysing the data from that. In the south, they're about to start the same process. They have had some delays because they have a few legal difficulties which they're taking further advice on. But what's happening is that we're gradually working our way down through these and knocking them out one by one, but it is an incredibly time-consuming process. Again, the CGI had spoken about they talked about a directive. I'm assuming that they were talking about the cross-border enforcement directive. I'm working at the moment with, as part of a working group along with the Department for Transport in London on implementing the cross-border enforcement directive. Unfortunately, that is not something that is going to allow, in fact, in any jurisdiction at all, the automatic transferal of penalty points. What the CBE directive is all about the exchange of information. So what we'll be able to do within Europe is get information about drivers, so who's the keeper of a car, who's been driving it, all those sorts of issues. But we're not going to be able to work our way around there. How do I actually take those penalty points and put them on your licence? So I think it is a groundbreaking project. It is a difficult project. There are a number of issues to solve, but we're getting there.
Is it, and again, I suppose I'm prerogative in my questioning, as I was with Sajini, is the work being done, undertaken by yourselves, is it worth the risk presented? I'll ask you the question, and you probably don't know off your head, but it's a valid question in my eyes. How many of our road deaths, many of our people who lose their lives on the roads in the last 5 years has been due to a driver who should have been who was disqualified in our jurisdiction?
In terms of disqualification, none that I know of. However, what our approach to road safety has always been you keep bearing down on the small things. You make you make road safety transgressions socially unacceptable, so you don't let people away with a small transgression. You just keep battering home the idea that in order to save lives, we've got to all make sure that we're all keeping to the speed limit, we're all wearing seat belts, not drinking and driving, all of those. So we find that if we keep battering away at every single issue, it creates a general sense and a general atmosphere of we need to think about road safety and we need to deal with it. So maybe not a specific example of if that driver had not been able to drive, that person wouldn't have been killed, but more a sense of road safety is about all of us working together and about us constantly being alert.
We talked about the risk, and again, I'm not too sure that a risk measure justifies a work. But is it true then that people change their practice in driving when they cross border? You know, because of the sense of I'm getting away with this, I can clock up 11 points on this side, I can clock up 11 points on this side, and I'd be fine. That's accumulation of 22 points. Is there that practice out there?
No, we don't have any evidence that that happens, but what we do know about is people who say have 4 points on one side of the border and 8 points on the other side of the border. Now, if they'd all been incurred on one side of the border, that person would be disqualified. So it's less a case of I'm across the border, I don't need to have to worry how I drive. It's more a case of because I got those points over there, they don't add to the ones I've got over here.
Yeah. With regards to the camera recognition, the vehicle recognition, are we missing a trick here? Is this, you know, because we talk about resource, we talk about pressures and resource, we talk about manpower. Is this something we should be using and we're not? Or is there these precious people in directorates or in departments who want to hold on to that information and are too precious to dish it out?
I don't know if that is...
Yes. Chair, as was mentioned by Sajini, the ANPR product is owned by Crime Operations Branch within PSNI, and it was, as it was everywhere, initially developed to be an intelligence gathering tool. I think there's certainly some work that we can do to look to see if we can develop that. I am currently liaising with my colleagues in crime operations, and I would also like to get some more information about what practices there are in other parts of the UK to see if we could learn from those and use those. But I think there are also some practicalities we would have to overcome. Mr. Lunn was mentioning about the insurance. You may detect a driver, you may detect a vehicle that says is flagging up with no insurance, but the person who's driving it is perfectly entitled to drive it. There's a suggestion we could use it for seatbelt detection of somebody not wearing their seatbelt. People have medical exemptions for not wearing seatbelts, and then we create another layer of administration and investigation to examine whether we should prosecute those offences. So this is something that we would like to explore with Crime Operations Branch and maybe come back to the committee at a further stage.
So there isn't any sort of legacy or practice of preciousness within a department. You don't detect that. You know, you see these crime movies on TV where the FBI goes in jurisdiction over the local sheriff. It's nothing like that. Are we content it's nothing like that?
I think it's fair to say, as we all know, Northern Ireland operates in a very different environment to other parts of the UK, and in that sense ANPR has been used differently or maybe more focusedly, certainly in terms of national security in Northern Ireland. That's not to say that we can't explore how we could move forward with that, but that's where we have been before. Yeah.
Natural progression and the natural course of things tells us that it's all about communicating now between jurisdictions, between constabularies, NCA, you know, Interpol, Europol, all of that. But what we're finding here is there's a problem between departments within our own constabulary.
I wouldn't say it is a problem, Chair. It is something that we need to explore further. And we are quite early days from the report being published. We don't know what, I personally don't know what these practices are that are taking part in other parts of the UK. So I think we need to look at those and then see if they are compatible with how we use the system in Northern Ireland, so that we don't compromise the other work that's going on around it.
Is there any human rights issues around sharing this information?
Sharing the information between,
between departments within the PSNI or between DVA, or is there any human rights with regards to the use of cameras, privacy issues, anything like that there?
Not that I'm aware of, but I would need to explore that further with crime operations.
Okay, and then we're getting a list here gathered up rightly with regards to questions. Just on the courts, Ronnie, this would be your opinion.
Yes.
And of course, it's something we're keen as a priority to look at with regards judicial system and how we can restructure it to make it slicker and quicker and smarter. I read your brief. You seem to be very confident or complimentary of the whole concept of this type of thing with regards to specific traffic court. Can you display some of that enthusiasm here today?
Well, I think, Chair, that it's a very, it's a very worthy recommendation that Ginny have made. I think it's absolutely worth considering. As I said in the opening remarks, we need to do the scoping exercise that Ginny have recommended. There are issues around the volume of cases and how many of our cases would actually qualify to go into the court. We need to look at that. In order to work out the costing, and we don't have costs in terms of this either at this stage. But it is quite clear from the report that it has had a significant impact in the two areas where the pilot has operated, and we do think that it's worthy of looking at it here. But we're not in a position to say yes, this will work for us in the way that it works or appears to work in Norfolk and Suffolk. But I think as part of the sort of innovative reform agenda in the problem-solving justice sphere, it is another area I think that is worth the effort looking at it.
We've seen many times before in government that there's always a well, or could be a well there, but the cogs turn very slowly. So what time are we talking about with regards to the scoping exercise, first of all, I suppose? And then if I can venture forward, what then would be the next step after a scoping exercise?
Well, I would like to think, and I don't want to give commitments because obviously there are a number of partner agencies that we need to work with. But I would like to hope that we could come back before the end of the financial year with some further thoughts in terms of this, having done some scoping work. In terms of what the steps are following that, well, I think Mr. Atwood indicated earlier, there is a requirement in the Public Prosecution Service to lead prosecutions under the Justice Act, and there would need to be legislative amendments. So that is another issue that would have to be taken forward in order to implement this. I don't want to commit to a time scale because, in all honesty, I'm not fully aware of all the facts at this stage.
Yeah. With regards to scoping exercise, though, can you put a time on that?
Well, I would hope to be able to come back, the Department would hope to be able to come back before the end of the financial year with some further information on it.
Do you need a legislative change for a pilot scheme, a pilot study?
I would have thought, because there is a requirement on the PPS to lead prosecutions, I would have thought, Chair, yes, we would. But I'm not a lawyer, and again, I would need to look into that.
Just a brief on that one.
Oh, okay.
Could you not ask them to lead the pilot?
Well, we could, but the idea of this is a move away from public prosecution service.
Or a more efficient model within it?
Well, I think that's a slightly different matter, and there is work ongoing at the moment, which Diane might mention in terms of the PSNI and the PPS, but it is a slightly different issue. Sorry, go ahead.
It is, and I have spoken to colleagues in Legacy and Justice Department, and I understand that there's a pilot which is going to start in February to run for 12 months, where anticipated guilty pleas, so very much what we were hearing about from CJI, and this will run in Belfast, will be separated out from the non-guilty pleas to see if there can be some efficiencies to speed up the process, and the traffic offences are going to be included in that. I think that would give us some good evidence of how we could proceed and the value of proceeding.
Are you content that it will be of benefit? If we go down this line, there will be a benefit. What we can't measure is the scale of benefit.
We can't measure the scale of benefit, and I suppose we're going on the basis of Sajini's report that would indicate there has been a benefit in England and Wales, and we're taking that at face value. And certainly anything that helps take cases out of the magistrates' court system, I think, is to be welcomed and will have some benefit. But at this point, we can't quantify that.
Would you be confident enough to have it in the programme for government, even the pilot study in the programme for government under Indicator 38, average time taken to complete criminal cases?
I think it's certainly something, Chair, that's worth considering. Again, I wouldn't want to give a commitment to that at this stage, because I think, this is at a very early stage. We've got the report. We're examining the report. We're doing our own internal work in terms of trying to look at a number of the issues. So, I wouldn't want to make that commitment, but I think it's certainly something that is worthy of consideration.
Why ask it? And it's not to put you on a hook,
no.
Ronnie. It's not my style.
No, I appreciate that.
But there are other examples of the pilot schemes in the programme for government, and it could well just be an add-on, and it could get you ticking a box in 5 years' time. Who knows? I'll leave it there. I'll put it out to members. Trevor Lunn.
Just in terms of the cross-border points issue, you said somebody could have 4 points one side, 8 points the other side. If they only had one licence, what happens in the south at the moment if somebody driving on a Northern Ireland licence, a UK licence, commits an offence which attracts a 3-point penalty? Is it recorded against their licence?
Yes, there's a system. There's a kind of a system where dummy licences are created. Probably it's easier for me to sort of talk about the north because I know the system better. But if a southern driver is caught, say speeding in the north and receives penalty points but holds a southern licence, there is a dummy record that's created on our licensing system, and the points would go onto that dummy licence. So if you, it would be possible, so there's always a record of them here, but if they're holding that southern licence, they're not being transferred onto the southern licence.
That just seemed like an Irish way to deal with the problem, doesn't it, really? Create a dummy licence.
Across the UK.
Well, because I'm wondering, is there a problem between Great Britain and Northern Ireland as well? I can give you a case, but just wonder, I mean, if somebody, this is a case, if somebody had a British licence, an English licence, because they lived in England for a long time, and they accumulated 10 points on it. And they accumulated those 10 points by driving in Northern Ireland, because they came home. But when they came home to Northern Ireland, they had taken out a Northern Ireland licence, so they actually had 2 licences. And they then attracted 3 more points, because they don't learn easily. And put them on their Northern Ireland licence. And there doesn't seem to be any way, I don't know if it's still the case, but there doesn't seem to be any way that the two, even within one jurisdiction, effectively could be married up. Again, they still had an insurance problem. I should go back to that.
Yeah.
But their declaration to the insurance company was 3 points. They would never even ask to see an English licence. So it goes on,
James may have to jump in if he wants to correct me on any of this, but I know that was possible certainly 20 years ago. My understanding now is that is not possible because of a declaration on the new licence within the licensing system now. But yes, historically it was possible to. I know of people who had points on a GB licence and then also had a Northern Ireland licence, but it's now no longer possible to hold both licences. So that was...
It can't be done anymore.
Yeah.
I'm relieved to hear that, because that was a friend of mine.
Okay. Party member? Only joking. Alex Atwood.
Well, I suppose one way I should put my hands up about the mutual recognition of penalty points, because that work was started a long time ago, and you'd like to have thought that it had been more progress by now, because when the work was started, there was resistance in Dublin to doing it, and then they got a bit of enthusiasm. But at least that was Baird in London. They had no enthusiasm for it at all and wouldn't cooperate, wouldn't involve themselves. Mike Penning, I think, was the minister at the time, and just said, over to you. Well, that's fine, because I believe people of Ireland should have control of their own interests. But a government that's meant to be showing some good authority wouldn't get involved in the issue of mutual recognition and said that they would watch from afar. But it is disappointing that it hasn't moved beyond where it is at the moment. I know it is difficult, and it does seem to me that Liz in particular is put into the hard places, because Liz was responsible for local government reform at one stage, a hard place, and now is responsible for, in part, for this, another hard place. So my comments aren't a comment on Liz, it is a comment upon words in the letter that we got from the department last week, which referred to the, as far as I recall, the limited scope of what was being proposed when it came to mutual recognition of driving qualifications. Well, Chair, it's not limited scope, because the 4 areas that are being looked at were deliberately looked at because that's where the greatest risk was.
Yes.
The highest number of the highest volume of offences and the greatest risk to road users. Use of the phone, careless driving, speeding, and the 4 that can't remember.
Seatbelts. Yeah.
So the reason why I said, was there some sense within the department that it was too difficult, was because of that comment that referred to limited scope. And I'm pleased to be reassured that it is difficult, but it's not too difficult. But it is still taking too long. So can I ask just 2 or 3 quick questions? The first is, without prejudice to recommendation 3, because I certainly reserve my position on that, I do think there should be scoping done, if not least so that there might be some legislation out of the department in this mandate, because at the moment it looks very threadbare. There seems to be very little coming from the department in respect to new legislation, and therefore this could be something to add more quality to what looks to be a threadbare approach at the moment. The second thing is the legislation in London on mutual recognition of disqualifications, is that being passed?
Yeah, it has been passed. There is a commencement order still to come, but they will, as far as I understand, and Ronnie, you might know more, they will hold off commencing it until the southern legislation's in place.
So I think we should be writing to Dublin and saying this mutual recognition fell in 2015, and now 2 years later, before it's actually the law will be passed, never mind it'll be put into place, and we should be saying to Dublin that that's what they should be given an opportunity to explain themselves, but it doesn't seem to me a good explanation. And the second question is, and I missed it, you referred to some national security issue in relation to technology. What was the reference?
Oh, I said that ANPR was used for intelligence gathering purposes, which then is a national, which includes national security issues.
So is there, and this is a pure speculative question, is there some issue around national security that is seeing not the wider use of the technology for other reasons? In other words, is there some elements within the security service or other places who are saying, no, we want to have sole use of technology and nothing else can get in the way, because national security has to come before other law enforcement? Is there anything like that going on? Because it does seem that the extension of this technology into other areas of potential crime hasn't moved very quickly. Is there some element running interference in this regard?
Well, the technology is used already in terms of alerting us to other areas of crime. So, for example, if someone is a missing person and that we know that they're in a vehicle, that will be put on. There'll be an alert put on so that cameras could pick it up or police officers could pick it up. So it is already being used, and it's been used for no insurance. We have no insurance alerts on the system, so it's already being used. It's just whether we can use it further without compromising the intelligence gathering issues.
Thank you very much.
Okay, Roy Beggs.
Again, just go back to the issue of the traffic courts again. When you look at the success that there's been in the schemes that have run elsewhere, then another factor that wasn't even discussed was that there's been a significant reduction in the number of cases that are withdrawn. So in other words, scheduled time works down from 85% to 43%. So there's a huge efficiency comes out of this by having a specialist unit dealing with it. And the cost that we were just quoted there earlier was something like £10, I think it was at 27 per case. Typically, what's it cost to put a bit of paper on any civil servant's desk? You know, typically, just for administering a bit of paper on your desk, is there any idea what that costs?
No, I mean, apart from anything else, it would depend on the grade of the civil servant and all of those things would have to be factored in. But I'm certainly not aware of any sort of, global figure in the way that you're asking. But
well, I know typically figures of £10 have been bandied about in the past. Just the number of papers are landing on anyone's desk in one day, and the cost of employing that employee for that day. I mean administrative cost is huge.
Yes.
So do you accept that there is huge potential here?
There are certainly unit costs for staff. Sorry, just to be clear about that, but not focusing on how much it would cost to process various different things. I do think that there is the potential. I mean, I've said that. We welcome the report. We think there is the potential for savings here, but we do need to do the costing exercise. And I think Chief Inspector and his colleague gave very general figures. I think we need to get into the detail of that and do our own costing work. And we haven't had a chance to do that yet.
And do you accept if we don't improve the efficiency and the speed of our court system, that it's police officers we're leaving on the streets?
I think anything that improves, the unavoidable delay situation, anything that improves that, I think, is to be welcomed. And obviously, there's a knock-on effect for all of the justice agencies.
Turning then to the use of technology, and Chief Inspector Pennington, the Northern Road Safety Partnership, I understand, has brought in an income of about £6 million a year, but only spent about £3 million. Is it part of this number plate recognition system?
No, it's not. It's
presumably, if it had digital equipment, it could be.
I'm not sure, to be is the honest answer, whether it could be connected or not. At the moment, it's not.
Yeah, but I understand at the present they're using film still as opposed to digital cameras. Who takes the decision for them spending their money and upgrading their equipment and possibly joining into a wider technology solution to improve community safety?
There is a Northern Ireland Road Safety Partnership Board, which meets quarterly, and at the moment there is an issue, I suppose, which is going through with DFP and DOJ to determine how the accumulated funds should be spent, and it's a matter which has gone for legal advice, and I'm sorry, it's a little bit outside of my remit here, and understand that it's also, there's been work with GB to see how similar schemes are worked there. It's to do with how the income is spent from the fines which are accumulated and from the driver improvement schemes. That is currently being progressed and if those funds can be released, the anticipation is that they will, as was the way the scheme was set up, that will be put back into road safety to updating our technology, for example, to be able to do camera detections after dark, to provide more safety camera vans and fixed cameras, but we're waiting for the release of the funds.
Would you accept that if they had modern digital technology, that they could be part of intelligent policing as well, to not just detect somebody who's speeding, but pick up key registration numbers of known criminals who may be out and about, and then add intelligence to policing, and as they spend their increasingly precious time, because there's few of them about?
I think that would be something that we'd have to look at, that if the remit of the scheme would allow that, but certainly it's something that I'll take back.
Okay, thank you.
Okay, Michaela?
Yeah, thank you, Chair. Again, thanks for the wait. And you heard me earlier with Brendan. I live in Strabane. Lifford in County Donegal is less than half a mile away. And I share the challenges that you would face, the difficult challenges, particularly around the summons issue that judges have to serve. If I posted a letter to Lifford from Strabane, which is less than half a mile away, that letter goes to England, and then it goes to Dublin, and then it goes to Lifford, which is a half a mile away, and vice versa, the other way around, Dublin, England, Strabane. So that's, and you know, the date on the summons for the court would be of long gone by the time the person receives the summons. So that's one of the issues that you would be faced with in that regard. Again, anecdotally, whether it's fact or fiction, I am aware of cases in my own locality on both sides of the border where people have been stopped for traffic offences. And I say it's anecdotal or fact or fiction, not my opinion. It's been said to me that because of the levels of bureaucracy around the paperwork and the challenges, because of the two jurisdictions, some of them are let go on both sides of the border.
Yeah.
That happens, you know, because of these challenges that you're actually discussing here today. So again, I said to Brendan, I said to yourselves, fully appreciate what you are trying to do in terms of road safety, but you have a mammoth task ahead of you in trying to get all of these issues resolved because of the different jurisdictions. So good luck with it.
Okay. There's no further questions from any of the members. So again, thank you very much for your time. I will apologise again for having you wait so long. I really do apologise. But listen, we wish you all the best, and we'll be keeping an eye, obviously. Ronnie, I don't know if you're aware, but we'll probably be doing a piece of work on the whole concept of traffic.
I am aware of that, Chair, yes.
So we'll keep you abreast of our work on that, and we'll keep abreast of yours.
I think it would be helpful if we could keep in touch in terms of...
Okay. Okay, thank you very much. Thank you. Okay, members, pushing on. I have a wee bit to get through here, so I would ask a plead for you to retain here, your attendance here, to try and get us through it all. Okay, can I seek agreement of members to refer the Hansards of the oral evidence sessions on the Sagini report to the Committee of Infrastructure for information for them? Okay. Can I seek the views of members on whether any further information or action is required? I will say, as I told Ronnie, we're going to do a piece of work on this now, so there'll be a paper produced for us as to how we go forward. Again, the big question mark is, what do we do that Ronnie's not doing? So we'll not want to duplicate, but we'll see what we can do. Okay, members content to carry on at that? Yep. Okay, agenda item number 8 then, SR 2016/373, the Sexual Offences Act 2003, Prescribed Police Stations Regulations, Northern Ireland 2016. I refer members to page 285 to 294 of the meeting pack. Can I remind members that at the meeting on the 22nd of September, the committee agreed that it was content with the proposal for a statutory rule to amend the Sexual Offences Act 2003, Prescribed Police Stations Regulations, Northern Ireland 2015. to make minor changes to the list of prescribed police stations in operation where convicted sex offenders can attend to notify their personal details to police as required under the statutory notification arrangements in the Sexual Offences Act 2003. I advise members that statutory rule, which is subject to negative resolution procedure, was laid by the Department of Justice on the 17th of October. There have been no changes to the policy content since SL1 was considered by the committee, and the examiner of statutory rules has confirmed that she has no issues to raise with regards to the technical aspects of the rule. So I'll ask members if they are content with the statutory rule.
Yep.
If so, I'll put the question that the Committee for Justice considered SR 2016/373, the Sexual Offences Act 2003 prescribed police stations regulations Northern Ireland 2016, and has no objections to the rule. Agreed?
Agreed.
Agenda item number 9, SR 2016/377, County Court Amendment number 2 rules, Northern Ireland 2016. Refer members to pages 296 to 304 of the packs. Can I remind members that at the meeting on the 22nd of September, the committee agreed that it was content with the proposal for a statutory rule which will amend the County Court rules, Northern Ireland 1981, which govern practice and procedure in the County Court. The rule will amend Order 48 and Form 209 and insert a new Form 200B into the 1981 rules as a result of provision made by the Licensing Act Northern Ireland 2016, which allows outdoor stadia designated as being of importance to the whole of Northern Ireland to apply for a licence to sell liquor. The Department of Communities has made regulations that designate the National Football Stadium at Windsor Park and the Irish Rugby Football Union Stadium at Ravenhill, such stadia. Initial applications for a liquor licence may be made to the County Court. Can I advise members that the statutory rule, which is subject to negative resolution procedure, was laid by the Department of Justice on the 17th of October. There have been no changes to the policy content since the SL1 was considered by the committee, and the examiner of statutory rules has confirmed that she has had no issues to raise with regard to the technical aspect of the rule. So can I ask members if they are content with the statutory rule? If so, I'll put the question that the Committee for Justice considered SR 2016/377, the County Court Amendment number 2 rules, Northern Ireland 2016, and has no objection to the rule. Agreed? Agenda item number 10, SL1, the Magistrates Court's Slavery and Trafficking Prevention Orders rules, Northern Ireland 2016. Can I refer members to pages 306 to 310 of the meeting pack? Advise members that the Magistrates Court Rules Committee is proposing to make a statutory rule under powers conferred by Article 13 of the Magistrates Court Northern Ireland Order 2016 to provide for the necessary court rules in respect of making an application for a slavery and trafficking prevention order. Statutory rule, which will be subject to the negative resolution procedure, will set out 3 specific rules for the courts in dealing with an STPO, and 4 template forms will accompany the proposed rule to be used for the application. Can I ask members if they are content with the proposed statutory rule or whether any further information is required at this stage? Content? Yeah. Okay. Agenda item number 11 is an SL1. Again, the Cost Protection Aarhus Convention Amendment Regulations Northern Ireland 2016. Can I refer members to pages 312 to 318 of the meeting pack? Can I advise members that the Department of Justice is proposing to make the statutory rule under powers conferred by Section 2.2 of the European Communities Act 1972 to amend the Costs Protection Aarhus Convention Regulations Northern Ireland 2013, which provide cost protection for certain environmental cases. The EU law requires that the cost of bringing a court challenge to certain decisions affecting the environment must not be prohibitively expensive. The requirement stems from the Aarhus Convention, a United Nations Convention on Environmental Rights to which the UK and EU are party, and would apply, for example, to the cost of a judicial review in respect to a road building or other significant construction. The statute rule will be subject to the negative resolution procedure. Can I remind members that the departmental officials attended the meeting on the 22nd of September to outline proposed revisions to the cost protection scheme for environmental challenges governed by the Cost Protection Aarhus Convention Regulations Northern Ireland 2013, following which the committee agreed that it was content with the proposals. This SL1 reflects the department's proposed changes. Can I ask members if they are content with the proposed statutory rule or whether they require further information? Content. Agenda item number 12, committee review of the need for stalking legislation in Northern Ireland, the handling arrangements of that. Can I refer members to pages 320 to 327 of the meeting pack? Can I remind members that at the meeting on the 27th of October, the committee agreed the aim, terms and reference and approach to be taken in relation to the review of the need for stocking legislation in Northern Ireland. The committee also agreed that the review should run from November to the 6th of April 2017 to allow the committee to report before Easter recess. Can I inform members that the paper prepared by the committee staff sets out a more detailed timeline for the review and proposals to seek written evidence and commission relevant research. The oral evidence session with department officials has been scheduled for the meeting on the Thursday 24th of November, and the seminar that the committee agreed to host with keynote speaker Laura Richards on the issue of stalking and legislation in our jurisdictions will take place on Thursday the 19th of January from 1:30 to 3 p.m. in the Senate chamber. All the key justice agencies and representatives from relevant stakeholder organisations will be invited to attend the seminar. Can I advise members that a draft letter inviting written evidence and a list of key stakeholders to which the letter will be sent has been prepared for consideration today. It is proposed that a period of 4 weeks is provided for the receipt of written submissions, and a sign posting notice on the review will also be placed in the three main papers, Belfast Telegraph, Irish News and the Newsletter. Proposals for 3 areas of research that the committee may wish to commission have also been identified. So, members, with regards to that, are members content with the outlined timetable for the review?
When's the consultation planned? Sorry.
It'll be a 4-week evidence session. 4 weeks to provide. Sorry, 4 weeks to provide. Sorry, keep me right. Sorry, I'll hand over. Yeah.
Okay. It'll be 4 weeks to respond, and the invites are due to go out probably Tuesday of next week.
So it'll be over the Christmas holiday period?
The deadline will be before the Christmas holidays.
That's correct.
Okay.
My maths is...
So are members content to provide the period of 4 weeks for receipt of written evidence? Yeah, happy enough. Can I ask members if they are content with the draft letter that will be sent to key stakeholders inviting written evidence and for a media signposting notice to issue?
Yep.
Can I ask members if they are content with the list of key stakeholders to which the letter will be sent, or whether there are any other organisations they would wish to add to the list? Nicola,
Chair, I'm just seeing there the written evidence, post 4 weeks submission written evidence. Sorry. It goes into the 3 main papers commencing Monday the 21st.
Yes.
I appreciate that the Belfast Telegraph, the Irish News and the Newsletter would be the 3 main papers, but west of the Ban there's the London Dairy Sentinel and the Dairy News, the Dairy Journal. I know we have no say over what papers it goes into, but
there may be a protocol. That's the only thing I'm worried about, because I would love the Ballymena Guardian to get a copy of this.
I know. But west of the Ban, it's the London Dairy Sentinel and the Dairy Journal.
Yes.
So,
well,
don't forget the Alarm Times.
Yes. well,
it's probably out of our hands, but you know,
I'm not sure of the procedure, to be honest with you. I don't know whether the clerk can take away and look at it.
Could you ask maybe just?
Well, the normal procedure is that we put it in the 3 main papers, because I think this has risen before, and once we start looking at smaller papers, all the members of various smaller papers, I mean, what we could look at if you wanted was maybe seeing whether we could do, I think the idea was we were going to do a platform piece on the review to highlight the committee was undertaking the review, and if you wanted, and we're looking at drafting that at the minute for the chair as a platform piece.
Right,
we could contact all the local papers to see if they'd be willing to put that in. It obviously doesn't run up costs, but the only issue is once we go into some of the more local papers, then generally we get a whole list of them.
Yeah, no, I understand that. Yeah,
but we could look at doing something like that. And the other thing is, if you're aware of anyone who would be willing to take anything on it, or even if you wanted to highlight it, we can give you the link that takes you to the committee page.
Okay.
The things that are going into the main papers now are only a signposting link notice.
Okay.
It takes you to the committee page.
Right.
So
okay.
If for example they would carry something that you would do an interview with them or whatever, we can give you the link, and we can give any of the members the link that if they'd be willing to put that in. It takes people to the committee webpage
Page
that's
on it,
set up
yeah.
for this.
No bother.
And you
we
know-
can do it that way.
And you know, that would be very useful, because you know yourself, a press release, an article in a paper is better than an advert in the paper. So,
Yes.
you know, that would be something that we could all probably individually run out
Yeah.
if we felt the
Yeah.
need to actually spread it out and among our local
Our
area.
own areas, yeah.
In the Twitter account?
Yes, I was going to
Yeah,
say
we're going
social
to use
media
the
too.
Twitter account as
Yeah.
well, or the
Tag us
committee.
all and then we can all.
Yeah.
The committee Twitter account as well. But I mean, if you're happy enough, then what we'll do is Marie to have a word with you individually over the next week or so, and then she can send you the link if you want to do something with your local papers, and you can insert the link into it. If that would be.
Can I also
way around
add?
it.
Yeah. Can I also add with regards to a list of stakeholders? I have been contacted by someone who is prepared to give evidence to the review. She would like to share her victim experience, so I think that would be very, very useful. Now, again, she's been communicating with me as a Miss Clark, and it may well be useful to maybe make contact with her and see if she would want to do a written response or evidence.
Is she Ballymena based?
No, I think she's English.
I didn't realise you could invite people to do that.
I think maybe victims obviously have a very harrowing story, but a very good story with regards to what we're doing, and it's getting it out and getting it into the system. So, and also, if I could add, she's informed me of a conference on stalking that was held in Hampshire. And this is me just trying to get in the record, but within that there have been 1, 2, 3, 4, 5, 6 people who took part in that stalking clinic, the conference, and it may well be that some of those people, there's a DCI from Hampshire Constabulary lead on domestic abuse, stalking and harassment for the last 3 years. He may be useful to contact, or at least invite him to give evidence. There's a Dr. I think it's Trey McEwen, who's a senior lecturer in clinical and forensic psychology in the Centre of Forensic Behaviour Science in Melbourne, Australia, took part in that. So again, it depends how far-reaching we want to be. A Dr. David Morton from a psychiatric hospital in Hampshire. A district crime prosecutor, Louise Holmes, qualified as solicitor in 1996. Becky Yates, a probation officer. And then there was Lucy Kay, an independent stalking advocacy caseworker. So there's those people who we may try and make contact with, even for a written submission.
Yeah.
So I just wanted to read the DCI, was a Tim Rowlandson. So again, I can hand this information over, but our members minded that we include those people within and ask them if they want to submit something in writing.
100%, yeah.
Because they seem to be a body of work already done in Hampshire, in England, with regards to this. And of course they're a wee bit more advanced in their stalking laws than we are. So.
Yeah, what's come out of that, yeah.
Yep, go ahead.
Just to go back to what Clara said, the committee has agreed if victims are willing to come forward to talk to the committee, they're keen to hear from them, and we will look at making particular arrangements if we need to, if the formal setting isn't the right environment, if you like to do it. We did it before when we did the inquiry into the experiences of victims and witnesses of the criminal justice system, where there was a number of families who wanted to speak to the committee about their experience of the criminal justice system, but wouldn't have been appropriate in the formal setting, and we made other arrangements, but we were still able to use their experiences. The committee was able to use them in the report, so we can look at that. So, I mean, if there's any example or any people you're aware of or anybody who approaches you, we can look at accommodating that as well. And just on the Australian one, I think Marie and I have met with our researchers, and that was one of the areas where she had highlighted where apparently Australia have had, their various regions have had stalking legislation in place for quite a while. So it's one of the areas we're hoping that they'll look at, because there may well be good lessons to learn because it's been in for a while. So again, that might be useful.
Okay. Well, I'll hand that over here. That's Clark's contact details, but then she would be able to get your contact. She'll be the gatekeeper for the rest of them, I think. Okay, members, are members content with all of that?
Yeah.
Are we content also to commission the research outlined in the paper? Are we all happy with that?
Yep.
Okay, I think I've covered all of those bases there with regards to the written evidence and the media signposting. Can I advise members that an electronic folder for the review will be created on the ECP? What's the ECP system?
Electronic Committee Pack System.
Right, okay. Right, there you go. So learn something new.
It's where you get your pack.
SkyDrive, we call it.
And in the bin, I call it, and the written submissions will be uploaded as soon as they come in for members' information. That might be quite useful, actually. Maybe lift it out of the bin. They will then be published on the committee webpage. Are members content then?
Yeah.
Okay, moving forward then. Agenda item number 13, Draft Northern Ireland Modern Slavery and Human Trafficking Strategy. 2016 and 17. Can I refer members to the relevant papers at pages 329 to 362 of the meeting pack? Can I remind members that at the meeting on the 27th October, the committee considered the results of the Department of Justice consultation on its 2016-17 draft Human Trafficking and Modern Slavery Strategy, and agreed to seek an assurance from the Department that the actions in the 2015-2016 strategy that had been deferred or only partially completed had all been incorporated in the new strategy, and to request clarification of why exploitation had not been included in the title of the strategy. And I advise members that the Department has now responded indicating that the starting point for the development of the 2016-17 strategy was to consider and include any outstanding actions from the 15-16 strategy, as well as identifying new priorities for action. It has made some slight revisions to a draft strategy to ensure that these actions are explicitly referenced, and has also provided a table highlighting the amendments. Can I inform members that the Department has also advised that the strategy's title reflects the requirement under Section 12 of the Human Trafficking and Exploitation, Criminal Justice and Support for Families Act, Northern Ireland 2015, that the Department should publish an annual strategy focusing on tackling serious modern slavery offences set out under Sections 1 and 2 of the Act, rather than other exploitation offences. I have a wee bit of an issue with this, members. I do think that whilst anything can have a title, it's the way they word the things in the letter. It's as if they're, well, we're in this regard, we're only worrying about the sections 1 and 2. I do think that there's serious questions whether the view is compatible with the whole Act and the nature of the Act and the whole mindset of the Act, and the fact that the victims of coercion into the sex trade not qualify as people suffering slavery-like circumstances. It looks to me that as the Act and the strategy very much takes into account coercive victims as well as trafficking victims. So again, I would write asking them, are they sure that it really should only cover sections 1 and 2, and then by way of that, what other offences are being left out that they see shouldn't be contained within this trafficking and exploitation strategy. If somebody's being exploited, well, you could have a lot of people coerced. So I worry that they're leaving a whole swathe of victim out in their strategy because they're only covering sections 1 and 2. So if we
have
get
any other laws where exploitation could be getting covered in? Is it a bit of a stalking thing? Is it just we have a law that doesn't really fit that?
Well, we have the wide-ranging the Act, the Human Trafficking Act, but they say that the strategy should only, which is an annual thing, should only really cover sections 1 and 2, and the offences contained within that, within the Act. So I'm asking, I suppose, well, are we limiting ourselves too much? Because the whole nature and scope of the legislation in the first place was to protect people. So are we limiting ourselves by just having that strategy fenced? And if that is the case, then what are we leaving out? What offences are in section 3 and 4 or whatever that's not been covered? So if we can maybe write in that guise. Okay. Any other questions? Can I seek the views of the members on whether they are content with the revised draft Northern Ireland Trafficking and Modern Slavery Strategy 2016-17?
Yeah.
Okay.
Content with it. I'm going to write back.
If we write, well, I'm content to leave it
until you get your answer.
here. Yeah, until we, well, that's okay. Yeah, leave it. I'll not ask the question until we get that answered then.
Right, okay.
It's due to be published anyway. Nothing will be.
Well, what they're seeking to publish it on the 18th of November, but what they're saying is that the committee doesn't require any further information, so
Yeah.
if you're writing back.
Well, I would like to hear the answer to that, but I wouldn't want it to hold up a strategy, I suppose, is the only thing. So we'll agree it as being content here, I think, for the sake of moving on, but I still would like them to answer that, because this is an annual thing. It's always going to come up. So we're content for it to be published, but then we'll see what... It's all about the title, but I'm thinking, well, if they're being so restrictive, what's the operational sense like? Okay.
To get it right now.
Well, we'll note it then as opposed to being content. Yeah, okay, as long as it doesn't hold anything up. Okay, thanks very much for that, for pulling me out of that hole there. That's great. Okay, moving on then. Agenda item number 14, Northern Ireland Prison Service Prisoner Development Model Information Paper. Refer members to the relevant papers at pages 364. Inform members that the Department has provided an update on the Northern Ireland Prison Service Prisoner Development Model. The paper highlights that within each prison establishment there is a prisoner development unit with a dedicated multidisciplinary team of Northern Ireland Prison Service and Probation Board staff that is the primary driver in coordinating rehabilitative work. It also provides information on the prisoner personal development plans, the funding provided for this work, recent developments, inspection findings, and how this work will be taken forward. Can I seek the views of members on whether they are content to note the information provided? Yep. Okay. Agenda item number 15, the Police Pensions Amendment Regulations Northern Ireland 2017. Proposed targeted consultation. Refer members to page 369 of the packs. Can I advise members that the Department is proposing to undertake a targeted consultation on the draft Police Pensions Amendment Regulations Northern Ireland 2017, which will make minor technical amendments, a minor change to wording, and correct a minor drafting error in the Police Pensions Regulations Northern Ireland 2015. Those regulations established a career average revalued earnings scheme for the payment of pensions and other benefits to members of the police service in Northern Ireland. The amendments will not make any policy change to the public sector pension reform design framework. And I seek the views of members on whether they are content with the Department to undertake a planned targeted consultation and to consider the draft regulations when the SL1 is available. Members content?
Yep.
Yeah.
Agenda item number 16, correspondence. I refer members to pages 375 to 415. Can I inform members there are 6 items of correspondence from pages 375? Can I advise members that I will draw their attention to a number of items and they will have the opportunity to comment. Item number 1, pages 377. Advise members that the Minister has written providing an update on the fetal abnormality working group. Can I inform members that the group provided its report to the Minister of Justice and the Minister of Health on the 11th of October, and they are actively considering the findings and proposals. The Ministers will then jointly submit the report to the Executive for its consideration. Decisions on the publication of the report and the next steps will be at the Executive to take. For the Executive to take. The Minister has also clarified the rationale for the Department appealing the High Court judgment on the judicial review of abortion law and indicated that the appeal was heard in June and judgment was reserved. Can I ask members to note the current position unless any further clarification or comment is made?
Is there just still no judgment then? Is it still reserved? Still no decision?
Yeah, still no decision yet at this stage. Okay, item number 4 then, page 389. Can I advise members that the Committee for Finance has provided departmental monthly forecast outturn data for August 2016-17. Can I inform members that data indicates slippage in relation to a number of Department of Justice projects in July and variations in the forecast outturn for June and July 2016 compared to the June monitoring round position. Can I seek the agreement of members to request further information from the Department of Justice on the projects that have slipped and the reasons for the variations in forecast outturn and the June monitoring round position? Members agreed. Item number 6 then, pages 414. Can I advise members that an invitation has been received from the Children's Law Centre to the Brexit seminar on Tuesday the 6th of December on what does it mean for children's rights. Can I ask members to advise the clerk if they would like to attend that? Ask members if they are content to action the other items of correspondence as outlined in the meeting pack, or whether anyone wants to comment on anything further? No. Okay. Agenda item number 7, chairperson's business. Number 1, informal meeting with the Northern Ireland Commissioner for Children and Young People. I met with her Tuesday, I think it was. Introductory meeting. Can I advise members that one of the issues she raised was the Youth Justice Review and the lack of any costed action plan in relation to the scoping study on children in the justice system. This was undertaken by the Department of Justice. The scoping study was launched in May 2015 and the previous Minister of Justice made a statement to the Assembly on it in March 2016. Could I seek agreement from members to request an oral briefing from the Department on the scoping study and the current position regarding a draft action plan? This is something that has rumbled on for years and years and years. And then they decided, on top of the Justice Review, the Youth Justice Review, that they do a scoping study some years later. And then we still haven't had any response yet from the scoping study. So it's a layer upon layer of nothingness, really. Are people happy enough with that? And also then when we get the oral briefing, also to propose that the Children's Commissioner comes up on at the same time on this issue.
Yep.
Okay. Agenda item number 18. Any other business? You'll be glad to know.
So very quickly, I think we should write to the Director General of the NCA to ask her comments on where she now sits in relation to funding under Fresh Start. And the reason I say that is that the Minister said in the Chamber during the week that NCA had not made any bid for monies. You know, last October they made a bid. They were then told to withdraw the bid because it was illustrative purposes only. Then there was this muddle about whether they could draw down Fresh Start. Then the Minister on the 1st of September wrote to the committee saying that it would now be for the department to make a bid to contract services from a third-party law enforcement agency, meaning the NCA. So here we are, over a year since they made a bid, which they had to withdraw, and nearly 3 months, September, October, November, nearly 3 months since the Minister advised us that it would be the department that had to shape a bid. And yet the Minister said this Monday that the NCA had made no bid for resources. So I think we should ask, the Minister's coming, the officials are coming for the parliamentary report, I think we should ask the DG of NCA, would she tell us what's going on? Because I'm completely at sea now as to what is going on.
Okay, are members content, as outlined by Alex, to write to the Director General of the NCA, asking those questions that Alex has posed? Agreed. Okay, agreed. Okay, thank you, Alex. Agenda item number 19, you'll be glad to know, date and time of next meeting, which is Thursday, 24th of November 2016 at 2 p.m, room 30, Parliament Buildings. Thank you very much.
Assembly Committee Room 30. This is the Northern Ireland Assembly Committee Room